Good morning, everybody. Happy Monday. Welcome to TCF Live. Good to have you all here. Judge Vincent Collada just took the bench in Ohio. Let's see what's going on.
Versus Carla M. Verona. Present in court is the defendant, who is accompanied by her attorney, Miss Mary Catherine Corrigan. We are here today for a change of plea hearing. It is the state's understanding that the defendant is prepared to withdraw her previously entered plea of not guilty and enter a plea of guilty to count 1, tampering with evidence, a felony of the 3rd degree, along with the attached firearm specification for 1 year. The state would move to dismiss the remaining count 2 at the time of sentencing. There is no agreement with regard to sentencing, and prison is mandatory in this case. Thank you.
Thank you. Ms. Corrigan, does that all sound accurate?
It does, Your Honor. Thank you.
And Ms. Verona, were you able to hear what the prosecutor and your lawyer just had to say regarding what they believe your intentions are here today?
Yes, I do, Your Honor.
And you can be seated at this time, both of you.
Okay.
I don't interpret that as any disrespect. It takes a little bit of time. It's easier to be sitting down when we go through everything here.
Thank you.
But you're able to hear what was said?
Yes, Your Honor.
They indicated to the court they believe it's your intention to withdraw your previously entered plea of not guilty to count 1 specification. Count 2 would get dismissed. We would defer sentencing to get some reports completed, come back on a future date for sentencing. Where there's no agreement between the parties regarding any recommendations for sentencing, each side is free to recommend to the court whatever sentence they feel is the right thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor, and more importantly, what you want to do today?
Yes, Your Honor.
Well, before I can accept your plea, I need to make sure you understand everything going on here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you have that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine those issues, I will ask you a series of questions. If at any point when I'm asking you the questions, if you're unsure or unclear of anything I'm asking you, if you need anything repeated or clarified, if you want a moment to talk with your lawyer to ask her questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything we're doing, all right?
Absolutely.
All right. Let's get started then. How old are you?
I am 48 years old, Your Honor.
Are you able to read and write the English language?
Yes, I am, Your Honor.
Any difficulty with that or difficulty understanding what you read in the English language?
No.
Are you a U.S. citizen?
Yes, I am.
Now, before coming into court here today, have you had any drugs or alcohol of any kind?
No, Your Honor.
What about in the last 48 hours?
No.
Not even prescribed medication?
Yes,
Nothing?
Your Honor. I am prescribed medication.
What prescribed medication would you have taken within the last couple of days?
I am on Lexapro. I am on hydroxyzine. I am on Prozocin. And then just stuff for my back. And that's it.
What is the stuff for your back?
The stuff for your back, is that,
I'm on
is that like a...
Roboxin.
Mm-hmm.
It's called Roboxin. And then I don't remember what it's called for my stomach for acid reflux.
Okay. So, in the paperwork I have, on the second page it reads, I'm not under the influence of any drugs or alcohol. I'm not taking any drugs or alcohol in a 48-hour period preceding this hearing. And I added, except for Lexapro, hydroxyzine, Prozocin, Roboxin, and acid reflux medication.
Yes, correct.
That sound accurate?
Yes, sure.
Now, any of those medications that I just listed that you've taken within the last couple days, do they in any way affect your ability to understand or appreciate where you are, what's going on around you, to communicate, anything?
If anything, they help me, right?
Okay. So no negative impact or influence because of these medications? in that
No,
regard?
not at all.
Now, you would have been served with a copy of this indictment back in very end of October. That's the document, maybe beginning of November. The document that sets forth the charges you're accused of committing. Do you remember getting that?
Yes, I do.
And at some point you had the chance to look that over?
Yes, Your Honor.
Now, in that indictment, you are charged with 2 counts. You're pleading guilty to the first count, so I'm going to review that with you. If you have any questions, make sure you ask. But what's alleged here in count 1 and what you're admitting to is on or about September 15th, 2025 and or September 16th, 2025 in Willoughby Lake County, Ohio, that you, knowing that an official proceeding or investigation was in progress or was about to be or likely to be instituted, that you altered, destroyed, concealed, or removed any record, document, or thing with purpose to impair its value or availability as evidence in such proceeding or investigation. That conduct constitutes the offense of tampering with evidence. It's a felony of the 3rd degree. Do you understand what you're charged with and pleading guilty to in count 1?
I do, Your Honor.
Any questions about it?
No.
Now, there's also a firearm specification attached to this count that alleges that you had a firearm on or about your person or under your control while you committed the offense of tampering with evidence. Understand what's alleged in that specification?
I do.
Any questions about it?
No, Your Honor.
Now, there's a second count of this indictment of obstructing justice. It's a felony of third degree. That's being dismissed pursuant to the agreement. Is that your understanding?
It is, Your Honor.
Any questions about that charge?
I do not.
Well, then before I can accept your plea of guilty to count one that I just read to you, I need to make sure you understand all the rights you're giving up by pleading guilty. And you, first of all, have the right to have a trial. And a trial could be me as a judge, where I would listen to all the evidence and I'd make that decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial. A jury trial would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence, and then those jurors would make that ultimate decision. And that ultimate decision reached by the jurors would have to be unanimous. Unanimous means all 12 of them would have to agree together, one way or the other, as each separate charge, whether you're guilty or not guilty. Do you understand that?
I do.
Do you understand by pleading guilty you're giving up your right to have a trial?
Yes, Your Honor.
Now, if we had a trial, you would have the right to have an attorney represent you at that trial. If you could not afford an attorney, the court would appoint one for you free of charge to do that. Do you understand that?
I do.
Excuse me. Now, at a trial, the prosecutor here would be representing the state of Ohio, and she would have what we refer to as the burden of proof. With her having the burden of proof, what that actually means is that it is her job, or she bears the responsibility or the obligation of proving you guilty at a trial before you could ever be found guilty. You're presumed innocent of the charges, and the presumption of innocence sticks with you and remains with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes, Your Honor.
Now, when I speak of this burden of proof, since this is a criminal case, that burden is what we refer to as proof beyond a reasonable doubt. Highest burden of proof we have in our justice system. And what it means, it's the amount of the evidence and the quality of that evidence the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of the charge beyond any reasonable doubt before you could ever be found guilty of this charge or specification at a trial. Do you understand that?
Mm-hmm. Yes, Your Honor.
You understand by pleading guilty, you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt at a trial?
Yes, Your Honor.
Now, in order to do that, or at least in order to try to do that, prosecutor would bring witnesses into the courtroom to testify for the state by answering questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same persons questions. That's called cross-examination. She could ask him anything she wanted to within certain rules. Do you understand that?
Yes, Your
Do you
Honor.
understand by pleading guilty you're giving up your right to cross-examine or confront those witnesses that would come in here and testify against you?
I do.
Now, you'd also have the right at a trial. You can call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not required to do that. But you have a right to do that if you want to. Do you understand that?
Yes, Your Honor.
And you further can request this court issue an order. We call that order a subpoena. What a subpoena would actually do is it would force or make someone come to court to testify for you and answer your lawyer's questions if they weren't willing to come in voluntarily on their own. Do you understand that?
Yes, Your Honor.
Do you realize you're giving up that right?
I do.
Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision or a choice that you would have to make. Do you understand that?
Yes.
And since that's your choice, what that really means then is that nobody else could force you or make you, nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But more importantly, the prosecutor is not allowed to call you as a witness and make you get up on the stand and force you to answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Okay.
Further understand that if we went to trial and you were found guilty, you would have the right to appeal or challenge that guilty finding to a higher court, a court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding. This court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. You understand that?
Yes, Your Honor.
All right, well, do you have any questions at all for me regarding any of these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No, Your Honor, I do not.
Do you understand them all?
Yes, Your Honor.
Do you still want to plead guilty?
I do.
Do you understand a guilty plea is a complete admission of guilt? It means you're admitting to the facts being alleged by the prosecutor. We're not going to argue later you didn't do it or it's someone else's fault or anything like that. Do you understand that?
Yes.
Further, as a result of pleading guilty, the effect of the guilty plea is that you'll be found guilty by the court.
Yes.
And then you will subsequently, on another day, be sentenced by the court. Do you understand that?
Yes, Your Honor.
Now, as far as sentencing goes, you're pleading guilty to a felony of the 3rd degree. This offense is punishable by a term in prison of a minimum of 9 months, a maximum of 36 months, or increments in between of either 12, 18, 24, 30. So at the time of sentencing, so I'll select one of those numbers, 9, 12, 18, 24, 30, or 36, and that would be the number of months in prison you'd have to serve for the tampering with evidence charge. You understand that?
Yes, Your Honor.
Now, the charge also has what we call a firearm specification that's attached to it. This firearm specification requires the court impose a mandatory prison term of 1 year. That has to be served prior to and consecutive to whatever prison sentence I impose on the tampering with evidence, the 9, 12, 18, 24, 30, or 36 months.
Yes, Your Honor.
So you serve the 1 year first, and then you would serve whatever the prison term is on the tampering with evidence. So they have to be served consecutively, which means one after the other. You understand that?
Yes.
I do not have the ability, if you've heard the term concurrent before, concurrent means sentences are run together at the same time. I'm not allowed, I don't have the authority to run the firearm specification, the prison term for the tampering charge concurrent. They have to be consecutive. Do you understand that? Any questions about that?
No.
Okay. And in as much as the firearm specification requires a mandatory prison sentence, that means I'm required to impose a prison sentence on the tampering with evidence charge as well, the 9 to 36 month range I mentioned. You understand that?
I do.
Now, are you currently on probation or parole to any other courts or agencies?
I am not, Your Honor.
Do you have any other criminal charges pending against you anywhere?
I do not.
Your Honor, I don't think she does. Judge, she does have quite a checkered criminal history and does have some substance abuse issues, and she doesn't believe she does. We don't know of it. We don't.
Fair enough.
I just want to.
I'll explain the reason I'm asking. It's nothing more than if you have a pending charge against you, felony charge, and you're sentenced to prison on that other case before you're sentenced on this case, I could run. I'd have to run consecutive. This firearm specification has to be consecutive to anything else.
Okay.
But that's only if you're sentenced to prison before you come back here for sentencing.
Yeah.
Doubt that's happening because you're not going to get out here. It doesn't appear to that's the case to go anywhere else.
Yeah, Your Honor, I don't believe.
Okay, well, that's the only reason I'm telling you that.
Yeah,
If you're
thank
sentenced
you.
to prison before you're sentenced here, I could run my prison term consecutive to that. That's the only reason I'm asking that. I can't run it, concurrent or consecutive to some possible future unknown sentence. It's already got to be imposed.
Yeah, I honestly, Your Honor, as far as I know, I don't have anything.
Fine. That's the reason I was asking. The only reason I was asking.
I've done everything in my possible ability when I fall down and if I fall down to get myself back into either a psych ward or any type of treatment. I never thought I'd be back in front of a judge again, Your Honor, so.
Were you? I may have asked you this, and if I did, I'll ask it again because I can't remember if I asked. Were you on probation or parole or post-release control to any other courts or agencies when this happened?
No.
Now, if a prison term is imposed in this case, upon your release from prison, you could be placed on what is called post-release control, sometimes referred to as parole. It's a period of supervision you would be on after you completed the prison sentence, and it could be, in this case, up to 2 years. You understand that?
Yes, Your Honor.
And if you're on post-release control and you're violating any of the conditions of your supervision, the parole authority can return you to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of whatever the prison term was imposed by the court. Do you understand that?
Yes, Your Honor.
Now, aside from the possible prison or the mandatory prison sentence I just mentioned, there's other sanctions that could be ordered. You could be fined in this case up to $10,000. You could be ordered to pay court costs. You could also be ordered to reimburse the county for any cost of confinement, community supervision, or treatment if any of that were applicable. Do you understand that?
Yes, Your Honor.
Now, a few moments ago, I was explaining the prison sentence, prison sentences, the possible prison sentences, and I told you it was mandatory, though, that prison had to be imposed. That means you are not eligible for probation, what's called community control sanctions. Do you understand that?
Yes, Your Honor.
Now, while you're not eligible for community control sanctions here at the time of sentencing, after you have served any mandatory prison term that would be imposed in this case it would be the 1 year for the firearm specification, you would be eligible at some point to request judicial release, which is a motion you could file with the court requesting to be released and put on community control sanctions. Now, you're not entitled to it, and it's not guaranteed you would get it, but you could request it after you serve some period of time after the mandatory prison sentence. You understand that?
Okay, thank you.
Lastly, when we come back here for sentencing, you'll have the right at that time to say anything you want me to know or consider.
Sure.
Your lawyer could speak on your behalf, recommend the sentence to the court. The prosecutor can also recommend the sentence to the court. Do you understand that?
Yes, Your Honor, thank you.
Do you understand that whatever the lawyers say at the time of sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation. I don't have to follow that if I didn't think it was the right thing to do. Do you understand that?
Yes, Your Honor.
All right, well, do you have any questions at all about the potential penalties you face by pleading guilty?
I do not,
You
Your Honor.
understand all the possible consequences?
I do.
Do you still want to plead guilty?
Yes, Your Honor.
Have you had enough time to discuss this case with your lawyer and have her review the reports with you, discuss issues, answer whatever questions you may have?
I have.
Are you satisfied with the advice and counsel of your lawyer?
I am. Yes.
Has she or has anyone else made any promises to you about what's going to happen at sentencing which is inducing you to plead guilty?
No, Your Honor.
Have you been threatened or coerced in any way to plead guilty?
No.
Are you entering the plea freely and voluntarily?
Yes.
All right, any questions for me then at this time regarding anything we've talked about, the rights you're giving up, the penalties you face, what you're pleading guilty to? Any questions?
I do not, Your Honor.
You still want to plead guilty?
Yes, Your Honor.
All right, then what's going to happen at this point, the prosecutor here is going to explain for me what she believes the facts would show if we had a trial. I want you to listen to what she says because then I'm going to have some follow-up questions for you, all right?
Yes, Your Honor.
All right. Ms. Timmerline?
Thank you, Your Honor. Had this matter proceeded to trial, the state would establish beyond a reasonable doubt that on September 15th, 2025, there was a shooting that took place at Fox Run Apartments in the city of Willoughby, Lake County, Ohio, where DeMonte Perry was shot and later died. The defendant was interviewed by the Willoughby Police Department where she admitted that she was aware of the shooting that occurred at Fox Run on September 15th, 2025, and that her son, Christopher Ferrona, had called her sometime after it happened. Christopher Ferrona told her that he was in trouble, and she told him that she was coming down there. Christopher Ferrona told the defendant that he had the gun. The defendant admitted to the Willoughby Police Department that she retrieved the gun from the bushes at Fox Run Apartments, again located in Willoughby, Lake County, Ohio, in order to assist Christopher Ferrona. She took the firearm and gave it to a drug dealer in Cleveland. The Willoughby Police Department was able to recover the firearm from that person and were able to confirm that the same firearm was used in the shooting on September 15th, 2025. Thank you.
Thank you. Ms. Ferrona, were you able to hear what the prosecutor had to say regarding what she believes the evidence would show if we had a trial?
Yes, I have.
What, if anything, do you have to say about those facts as she presented them? Are they true? Did you do what she said?
Okay, Your Honor, to a degree. When my son called me, I didn't go into where he was. We called Melvin Harris. I did go as close as I could. I did not go in. My son told me the gun...
You did not go in where?
To the apartment.
To the apartment where it had happened. The next day, my child had my food card. This can all be proven.
I want to know if you tampered with this gun, which was evidence in a proceeding.
He wants to know, did you go and retrieve the gun
I
from
did,
the
Your
bushes?
Honor. Afterwards, yes.
Knowing that it was potentially evidence in a criminal
I
investigation?
did. Yes, Your Honor.
And you possessed it when you got it?
Yes, I did.
Anything else you'll be able to explain to the probation department. I just
Okay.
want to find out whether you are admitting to the specific elements of the offense that you...
Okay, I didn't know if you wanted to know exactly what had happened.
You're going to get a chance, you're going to go to the probation department and meet with them and give them your own version twice of what happened. You can talk to them orally and have an oral interview with them, and you're also going to get a chance to write it out if you want.
Okay.
So you'll get that opportunity. I'll get a chance to look at it. So I'm not review that.
Thank you.
Not an opportunity, I will review it. So, but the point here is just that you're admitting to the specific elements of the charge,
Okay.
which is what you just said, that you got that gun
Yeah.
knowing that it was evidence in a criminal proceeding.
Yeah, I'm sorry, I was just a little confused.
That's all right.
Thank you.
Did you know that he had died at that point, though?
I did not.
Right,
It
well,
doesn't, I don't think it changes
No, it doesn't
the
change
actual
that.
elements of the facts.
Yeah,
but
Because it's just that
totally-
it's a criminal investigation
Yes.
that you knew was going
Correct.
on. You knew that, correct?
Yes,
Yeah.
yes.
Very well then, regarding count 1, charging you with tampering with evidence, a felony of the 3rd degree, what is your plea to that?
Guilty.
Regarding the 1-year firearm specification, what is your plea to that?
Guilty.
All right, I have in my possession at this time a 4-page document called a written plea of guilty and judgment entry, which explains everything I've just explained to you. Before I can accept your plea, I need to make sure you understand that document and that you sign it here in open court. Now, my understanding is before I came out here, you had a chance to go over that document with your lawyer, is that correct?
Yes, Your Honor.
Ms. Corrigan, is that accurate? Did you review that with
I did,
Ms.
Judge.
Frona?
Yes.
Read it over with her?
Yes, sir.
Did she indicate an understanding of it to you when you did that?
She did, very much so.
Is that correct, Ms. Frona? So you understand the document?
Yes, Your Honor.
Any questions for me about what it says?
No, Your Honor.
It also appears you signed the document. Did you in fact sign it?
Yes.
You witnessed that, Ms. Corrigan?
I did.
And Ms. Simline, you as well?
Yes, Your Honor.
Very well, then at this time, the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with her lawyer, advised of all her constitutional rights, made a knowing, intelligent, and voluntary waiver of those rights. Court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea. Find the defendant guilty of count 1, tampering with evidence, a felony of the 3rd degree in violation of 2921.12A1, along with the firearm specification. Count 2 will be dismissed. I'm going to defer sentencing, order a pre-sentence report and investigation, and I'll continue defendant's bond. Is there anything else for the record at this time, Ms. Himmeline?
Your Honor, we did a victim impact statement as well.
Victim impact statement. Ms. Corrigan, anything else?
No, thank you, Judge.
Thank you.
All right, I'll be in to see you. Depending on the weather, it might not be tomorrow, but
That's fine.
Good morning, everybody. TCF Live on a Monday. Welcome. Good to have you here. If you are new to the show, welcome. Happy Monday to you as well. So basically what we do here is we spend 3 hours hopping around the country from court to court to court, seeing what's going on. And then in the 4th hour, we generally talk about some of the things that we saw, or I bring up some other news. If you're a channel member, you have the ability to call in and talk to me, so we have fun there as well. So courts are still kind of booting up here this morning. So what's going on is a little bit limited, but let's go to Molly Hennessy Greenwald. There we go. Let's see what's going on there.
Langston Nevels, case number 2619 SD. This is the date and time set for a arraignment this morning. May I please have appearances for the record?
Thank you, Your Honor. Jonathan Foreman, Office of the Public Defender, here with Mr. Nevels for the purposes of arraignment only today. We waive any in-person appearances for his hearing this morning.
Thank you. Mr. Nevels, can you please unmute, sir?
Hello.
Hello, can you please confirm you can hear and see me and Mr. Foreman?
Yes, I can hear and see you both.
This is called an arraignment. We're here today so I can inform you of the charges against you, the maximum possible penalties, and all of your rights. Mr. Nevels, you're charged in this misdemeanor complaint. Currently, you're charged with count 1 of operating while intoxicated, and that's a misdemeanor. It's punishable by up to 93 days in jail, and a minimum fine of $100, a maximum fine of $500. Additionally, there may be sanctions ordered by the Secretary of State for your driver's license. And then in the alternative to count 1, you're charged with the crime of a person operating as a minor with any BAC. That is punishable by up to $250 and up to 360 hours of community service, also some driver's license sanctions. And Mr. Foreman, just note, please, that that is the complaint that I've read. I think that our online JIS system has a different charge, is referencing the alternative count 2 as a minor with the BAC second offense, but that's not how it's charged.
We discussed that, and I appreciate that clarification, Judge.
Thank you. So I want Mr. Nevels to make sure that he understands these charges and the possible penalties. Do you understand those, Mr. Nevels?
Yes, I understand.
And then I want you to know you have a right to an attorney to assist you, and if you can't afford an attorney, one will be provided for you at public expense. Mr. Foreman's here representing you from our public defender's office. Mr. Foreman, is Mr. Nevels making an application to your office?
He's an MSU student, Judge, so I've given him the legal services at MSU their contact information.
Okay, Mr. Nevels, is that all correct?
Yes.
So we'll talk about that again, but it'll be important for you to contact MSU Legal Services immediately after our hearing and provide them the dates that I anticipate I'll give you shortly.
Yes, ma'am.
Then I also want you to know, Mr. Nevels, you have a right to a trial on these charges where you would have many rights available to you. Mr. Foreman, did you review the trial rights with your client?
I did.
And how are we proceeding today?
Entering a not guilty plea, Judge.
So we're setting this for a pretrial on February 25th at 11 a.m. Final pretrial is April 13th at 9:30, and jury selection April 14th at 1. And Mr. Nevels, I have an address for you in Pontiac, Michigan. Is that a good address?
Yes, ma'am.
Okay, that's the address the court will continue to use. Mr. Foreman, on bond.
Thank you, Judge. Just so I'll note that my information is Mr. Nevels has no prior criminal offenses of any kind. He does have that permanent address in Pontiac, but he's also an MSU student, so he's local, but he prefers to get his mail out there. I just think it's more reliable that way. He's a junior studying finance, so he certainly has a lot going for him. I apologize about that, Judge. So we would request a personal recognizance bond, given his ties to the community and given his lack of a history.
Thank you. Mr. Nevels, did you hear what Mr. Foreman told me?
Yes, ma'am.
Is that all true and accurate?
Yes, that is all true and accurate.
That helps me make my bond decision where I need to consider 2 main factors. The first is, will the person always appear for their court dates? Mr. Nevels, you've appeared here today for your very first court date, timely, attentively. You've confirmed a permanent address. You have ties to this community as a student. You've assured me that you will be contacting legal services at MSU, so you'll have continued representation. All those things give me good reason to believe that you'll always appear for your court dates. Am I right about all that?
Yes, ma'am.
And then the other factor I need to think about is public safety. There are public safety concerns inherent in these allegations, where the allegation is you operated a motor vehicle while intoxicated on the roads of this community. They are slightly elevated for you, Mr. Nevels, because of your age. You're charged as someone who not only was allegedly driving while intoxicated, but is illegal for them to even purchase or consume alcohol. So there are public safety concerns. They can be addressed through bond conditions. And as long as you're committed to complying with these bond conditions, I agree a personal bond is appropriate. So with that, Mr. Nevels, your bond is $500 personal recognizance. You do not have to post any money bail. I'm releasing you because I trust you will come back to court and I trust you will comply with my bond conditions. And they are as follows. You must appear as directed. You may not leave the state of Michigan without permission of the court. You must not commit any crime while on bond to this court. You must not purchase, possess, or consume alcohol, recreational marijuana, or any illegal controlled substance. You must submit to random drug testing that'll be overseen here at the court, and you must not provide a positive, diluted, or adulterated sample to the drug testing agency. Mr. Nevels, is there any reason why you can't appear in person to this court by 2 p.m. tomorrow? That would be Tuesday, January 27th.
No, I can appear by tomorrow.
Okay, so I'm ordering that you must appear. You can come anytime today and through tomorrow by 2. You'll go to our probation department and you'll get referred for that random drug testing.
Okay, thank you.
And then you must not engage in any illegal driving. And Mr. Nevels, we have fingerprints taken. So I think that's all for me. Mr. Foreman, anything further from you?
No, Your Honor, thank you.
Very good. So just a reminder, Mr. Neville's important you contact MSU Legal Services immediately. They'll want to know the court dates I gave you, and just so you're ready and they're prepared to proceed on those dates.
Okay, can you please repeat those court dates so I can write them down, please?
Yes, you ready? The first
Yes.
court date is called a pretrial, and that is set for February 25th at 11.
Okay.
And the second is final pretrial, April 13th, 9:30. And then the last date is a jury selection on April 14th at 1 p.m.
Yeah, I got it.
Very good. Thank you very much, and good luck to you, Mr. Nevels. That's all for this case.
Thank you.
Good morning once again, everybody. TCF Live. It's Monday. Good to have you all here. Leah, thank you for becoming a channel member. Very much appreciate that. You're in the best community in the LawTube space. And I've said it before. I don't just say that because I run it. I say it because it's true. The people here are the best. They're involved. They're committed. And this is just a great place to be. But now that you're a member, you get access to the pre-show. You get the ability to call in and talk to me during the 4th hour. You get a discount in our store, all sorts of things. So be sure to check that out. And again, thanks so much. Let's do this. Let's go to Florida. Wade Mercer is just getting his day started. Let's see what's going on.
Hi, fiance. Your fiance is in the courtroom. Mr. Hill, you're here because you're accused of violating the terms of your county probation in case 24-693 CT. Mr. Hill, I'm going to appoint the public defender's office to represent you. I'm going to ask that you listen to Mr. McDaniel, your attorney.
Your Honor, I've spoken to Mr. Hill at this point in time. Mr. Hill, I did go through the documents you had. There's still the issue that you didn't do your 50 hours of community service. Yeah, it's still the issue that you allegedly stopped reporting in. There is an offer. It's offers 30 days in the county jail. You'd have 3 days jail credit, and you'd be eligible for any game time while you're out there, as I told you earlier. So you should be getting out of there probably about 3 weeks if you want to resolve this morning. Do you want to go ahead and resolve it?
Yes, sir.
All right. Your Honor, I've talked to Mr. Hill, and we're going to go ahead and admit that he violated his probation. Understanding if he says 30 days in the county jail, have 3 days jail credit. I don't believe there's any remaining fines owed on the case, and that'll resolve this case today.
Thank you. Mr. Mitchell's that agreeable with the state?
It is, Your Honor.
Thank you. So, Mr. Hill, I think the tentative offer was 60 days, but then your fiance brought in the documentation that you did do the DUI school, and it was done about 2 weeks after the warrant. So that's why the offer changed, because you did do more than what we had originally thought. So, Mr. Hill, this agreement will resolve it. Is this the plea you would like to enter, sir?
Yes, sir, but I was also did other classes besides that class.
Right. The other thing the DUI school constitutes takes care of your counseling requirements as long as you enroll within 60 days. I don't think you got that part done, but the problem is that a couple of problems. You quit reporting allegedly in the spring, and then you were told in August to turn yourself in, and here we are in January. So if you want to resolve it today, the offer is 30 days in jail, but you don't have to resolve that. You don't have to take that offer. We can just, you're not going to have a bond because it's a violation of probation, but we'll see at an upcoming court date if you wish. If you want to resolve it today, that's okay too.
I like to resolve it today.
Okay, so do you want to admit that you violated probation, knowing that I'm going to sentence you to that agreed upon term?
So I had to sit here for how many days?
Well, you have 3 days credit, so you have 27 days left. Now, under Florida law, you may get some gain time for your good behavior. I cannot promise you that. You can get up to 10 days a month at the jail, but that's between you and the jail, and that's dependent upon you're following the jail rules. So if you did that, you would be out in 17 or 18 days, but I can't promise you that. You get out there and you have trouble, you don't follow the jail rules, you're going to do 27 days or closer to that. Any other questions? So is this admission you would like to enter and the agreement you would like to enter or not?
No, I was trying to get out quicker than that, sir.
All right, no problem. So we'll see at your next court date. You've got no bond for the time being. Mr. McDaniel, what court date would you like them set for?
Mr. Hill, you realize the next court date's about 30 days from now. Are you sure you don't want to resolve this?
I would like to resolve it because I have a job and that's what I'm
What's
trying
next
to.
jail court date, February 12th?
Mr. Hill, we're not going to beg you to come in and report into your probation officer. The note says the officer talked to you in August and said you need to come in and take care of this. Here it is, January. So we'll see you at the next court date. That'd be
February
when,
11th, jail docket, will be a jail.
we'll see you on the jail docket date. If Mr. McDaniel wants to bring you up earlier, then we'll do that. Mr. McDaniel, if you talk to him next time you're out there, please. I'm gonna see if your fiance has any questions. Ma'am, do you have any questions?
Pre-trial.
Just pre-trial.
Pre-trial.
I think he just said there's no other option. I think he should try to resolve it today.
That time's passed. We got a bunch of cases to deal with, and I've got to pick a jury this morning. So we'll see him in another court date. May see him tomorrow if he wants to. Mr. Hill, have a good day, sir. Thank you for coming, ma'am. Next case is Jeffrey Pritchett. Mr. Pritchett, good morning. Mr. Pritchett, you're here because you've been accused of one count of misdemeanor assault and one count of misdemeanor domestic violence battery. Mr. Pritchett, there is probable cause for the charges. The good news is that you have almost no criminal history. I think I saw one marijuana charge over 20 years ago last year, and that's all I saw. Mr. Pritchett, is that the only criminal history you have, sir?
Yes, sir. That was just for like one joint, like a disorderly conduct or something a long time ago.
Okay. All right. I'm going to appoint the public defender's office to represent you, and I'm going to listen to the attorneys before I address your bond amount, or your release status. Mr. McDaniel,
Your
anything?
Honor, we just asked for a conditional release.
Thank you, Mr. Mitchell.
No objection to a conditional release.
Mr. Pritchett, do you have somewhere else you can live other than the residence where the alleged victim lives?
Yes, sir. I have somewhere to go.
Where?
I have a friend that's in an RV park. We have relatives and things like that. The thing is, I'm kind of new to all this, and I think I have the flu. I've had a fever for the few days, but my biggest thing is my mother.
Sorry,
That's where we live.
I didn't mean to laugh. But when you said that, Corporal Campbell just gradually slid off the screen, so I couldn't see him. But go ahead, please. Start over so I can make sure I hear everything you're saying, sir.
I'm sorry, my mouth's really dry. But it's my mother's house, and we all live there, and I'm the bread earner pretty much. So,
Okay.
I mean, I would like to get counseling with her and work it out and, figure it out. And I've never had any trouble with it whenever.
Let me explain that. You're gonna be ordered to have no contact with her for the time being. Now, if she wants contact and if you want contact, I will consider it probably with some counseling in a place. Obviously, I've got to give the state attorney's office a chance to have input also. But right now, she's not here asking for contact. So when you leave the jail, you can have no contact. And what you can do is contact law enforcement about getting clothing and other belongings you might need for work from the home, and law enforcement will escort you to do that. But you've got to live somewhere else. And when you get to the conditional release office, if I give you a conditional release, you've got to have an address. You got to be able to give them an address. So knowing all of that, you've got somewhere else to stay, at least for the time being, correct?
Yes, sir.
All right. So I'm going to offer you the conditional release. I always give a bond option. Some people prefer the bond. Your bond will be $2,500 cash or surety. I am going to offer you a conditional release. Either way, you have a condition of no contact with the alleged victim. Do you have any questions, Mr. Pritchett?
No, sir.
And you want the bond or the conditional release?
The conditional release, we're broke pretty much, so.
So, Mr. Pritchett, what's going to happen then, sir, is they're going to let you use the phone to call transportation, call for transportation, or to try to make sure you got a place to live. Then they're going to bring you to the jail, from the jail to the courthouse. Mr. Ham will meet with you at the courthouse, and then you will be, once they go over everything with you, you'll be free to go. If you call friends or family, you can tell them that you need to be picked up here. You can be picked up at the courthouse in 30 to 45 minutes. You call whoever you wish other than the alleged victim.
All right. Okay,
Thank you for clarifying. The bond is $2,500 each. Thank you. Mr. Pritchett, you're also going to get a notice for your court date, and that's going to be March the 2nd at 9 a.m. Mr. Pritchett, we'll see you at the courthouse in a little while, okay?
All right, thank you.
Yes, sir.
We're officially in March for both arraignment
I don't
cases.
want to put it in the record. Next case is Justin Brewer. Thank you. Mr. Brewer, good morning. Mr. Brewer, you're here for a holdout of Santa Rosa County. That's a violation of probation warrant. It has no bond on it. Mr. Brewer, what that means is you're going to be held for that county, sir. Today is a Monday, so that's very possible they'll get you one day this week. Not always, but usually a week or less is about right for those counties that far away from us. So you're going to get, when you get picked up, you'll go to that county. You'll go to another first appearance in that county. Any questions, Mr. Brewer?
No, sir.
Have a good day, sir.
Thank you.
Thank you. Tommy Thurman. Mr. Thurman, good morning. Mr. Thurman, you're here because you've been accused of one count of obtaining property by false pretenses, less than $20,000 in value. Mr. Thurman, there is probable cause in the complaint. I'm somewhat familiar with the criminal history. I took a look at it this morning. I think you're entitled to a bond. I'm going to listen to the attorneys and see if they have any additional information before I set that bond. Mr. McDaniel, anything?
Your Honor, we just asked for a reasonable bond.
What's your thoughts on the cash bond?
Mr. Thurman, are you still just wanting a surety bond? Or do you want? a
I
cash
don't know
bond?
which bonds, which
I explained it to you out there over and over, and you said you want a surety bond. Which one do you want, surety bond or a cash bond?
I'll take the bonds one.
Okay. Mr. Mitchell, anything? Mr. Thurman, your bond's $5,000 cash or surety. You have a condition to have no contact with the alleged victim. You'll get to use the phone in just a few minutes, sir, to try to post the bond. Any questions, Mr. Thurman?
No, sir.
Have a good day, sir. And I think what maybe the last case is Hunter Polly.
Judge, next arraignment court date?
Thank you. On who? On who?
On Thurman.
March. That would be the
March 3rd.
March the 3rd. So we're in March on
Yeah,
felonies
we're in
now.
March on both.
March the 3rd
March
at
the
8:30, Corporal. 8:30. Thank you for reminding me. Mr. Polly, good morning. Mr. Polly, you here for first
Good
appearance
morning.
accused of violating the terms of your county probation in case 24417 MM. Mr. Polly, there is, I'm going to appoint the public defender's officer to represent you, Mr. Polly. I'm going to ask that you listen to Mr. McDaniel, your attorney, and we'll see if you have any questions in just a moment.
Your Honor, I spoke to Mr. Pauly. He's going to admit they violated his probation. Understanding he's going to be sentenced to 90 days in the county jail. He'll have 6 days jail credit, and the remaining fine will be, hopefully he'll work off while he's in the trustee bay.
370. Mr. Mitchell, is that agreeable with the state?
It is, Your Honor. You said 6 days credit?
6.
6 days. That is agreeable.
Thank you. And Mr. Polly, did you hear that agreement?
Yes, sir.
Mr. Polly, do you have any questions about that agreement?
I was wondering if we could possibly get it down to less time. My first child is going to be born here on April 12th is our date. I would hate to miss that, man. That's it's a big thing.
You'll be out by April 12th.
Okay.
Well, let's see.
Given game time, I think he should be out by then and the time.
Okay, let's do this. I feel like you're going to be out because there's a good chance you're going to get some trustee time. If he's still there the last day of March, bring him back to first appearance so we can see where he stands, please, Corporal. Okay.
Yes, sir.
So I don't want you to miss the birth of your child, but you got probation, never came back, it appears, at all. So I think 90 days is where I would be on the sentence. So knowing that I'll review the case, if you're still there on the last day of March, the last working day of March, knowing that, is this what you want to do? Is this a mission you'd like to enter?
Yes, sir.
I'm going to accept your admission that you violated the terms and conditions of your probation. I'm going to revoke that probation, sentence you to 90 days in jail. The court costs and fines will be brought forward. They're the amount of $370. And I've told you on the record that if you're still there at the end of March, I'll review your case. And if you've done everything you're supposed to do and you're still there, then I'm going to strongly consider letting you out for the upcoming birth of your child. Any other questions, sir?
No, sir. Thank you.
Yes, sir. Have a good day.
You too.
Corporal, how you feeling?
Feeling all right.
So you get feeling bad, let me know, okay?
Yes, sir, I sure will.
That's funny how you slid over when he mentioned having the flu. I think I probably done the same thing.
Yeah, I was standing right next to him, so.
Corporal, anything else from the jail this morning?
No, sir. No, sir.
Mr. Mitchell, anything else from the state?
Nothing else from the state.
Mr. McDaniel from the defense?
Nothing else, Sean.
All right, so ladies and gentlemen, that concludes first appearances this morning. We do have a jury selection scheduled for 9 a.m., so we should be putting that on Zoom and YouTube. But
Morning once again, everybody. It's TCF Live. It's Monday. Somehow you all made it here. Give me just a moment There we go. Just getting the next court set up. Again, everybody's just kind of coming online all at once here. Let's go to Texas and Judge West, see how the Monday fashion show is starting out.
And so here's the thing. Remember what I said when you were here before, right? Talk to them. They all charge different amounts, have different payment plans. Bring me the names of who you've talked to. I say the same thing to everybody, so I know I said it to you. And what did I say that could happen if you didn't do what I told you to do? Right, so you don't want to go to jail just because you don't do what I asked you to do, right? It's easy, just talk to 3 lawyers. Then if you can't afford them, there's options, but you have to follow the rules first. It's just that simple. If you can't follow the rules, you're going to end up in jail. Okay, so I'm going to reset your case 2 weeks. You have 2 weeks now to talk to 3 attorneys or get one hired. If you don't do that, then your bond will be raised for not following that court order. Yes, ma'am.
I'm going through a transition right now. I'm not able to work because I just got my kid the case with home.
Just do what I'm asking you to do, and then we'll talk about your options when you come back, okay? If you talk to them, you do what I say, you can't afford them, you can't come up with the money, then there's some options for you to maybe get a court-appointed attorney. But you're going to be required to follow those directions first, okay? All right, step in front of the clerk. Justin Payne. Good morning. Good. You're Justin Payne? Mr. Payne, were you able to get someone hired?
Yes, ma'am.
Who'd you hire? Okay. Did he, you've paid him and everything, or you're going to?
No, I had made it non-payment on it. He said I had to text him. He said something like trial or some hard comment or something. So he went back this week.
Okay. So how much more do you need to pay him before? So have you hired him? I guess what I'm saying is sometimes they'll take a down payment for whatever is going to get them on your case.
Mm-hmm.
You've already done all of that?
Yeah, I did a couple hundred.
Y'all didn't hear from him?
I'm working to make sure, Judge.
Yeah, I know.
Well, I think, I don't know if he's on our docket, but I know
He's in Hardin County.
he'll be around there. They're not starting back till, tomorrow.
Okay.
But he hasn't filed anything.
But he's coming today? Do me a favor, just have a seat here in the courtroom until Mr. Kimler gets here. It sounds like he'll be here this morning. Don't leave until we tell you to, okay? Thank you.
Yeah, they're starting back tomorrow.
Okay. Brittany Davis. Mm-hmm. Good morning, you're Brittany Davis?
Yes, ma'am.
So, Ms. Davis, what happened with your drug patch?
I had a death in my family. I went to Dallas. My daughter got sick and they fell off in the hospital. I have documentation to show where I was and when she was discharged.
What does any of that have to do with your drug patch coming
It
off?
fell off and I was in Dallas. I wasn't even involved at the time.
Have a seat in the jury box. We're going to get you tested this morning. Richard Volry. Good morning, sir. You're Richard Volry? And Mr. Volry, this is your initial appearance in cause number 25 DCCR 1746. You're charged with aggravated assault with a deadly weapon from October 21st of 2025. And since you have made bond in your case, have you had an opportunity to try to hire a lawyer? All right, so what I'm going to do, sir, is reset your case for about 30 days or so. Give you some time to try to hire a lawyer. If you get a lawyer hired before the next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Bring me back the names of the lawyers you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would have to go back to jail. Do you understand? All right, if you'll step in front of the clerk, she'll give you a reset notice.
So while she pulls up the next contestant real quick, because the previous one had talked about her drug patch falling off, I just looked it up. According to Farm Check, which is a maker of those drug patches, the falling off is a rare occurrence, can be because of excessive sweat or soaking like in a hot tub can cause it. Improper application, but that tends to be found out very quickly. Or if it's being worn too long, over 14 days, just your cellular shedding can cause it to lose contact. But specifically, it's designed to be tamper evident, so if you try to remove it yourself, they'll know it. So just some FYIs there for you.
Mr. Ramirez, just have a seat for a few minutes and we'll check on all of that, okay? I do remember something about that. Probably because of...
Barbara, thank you for the $10. I very much appreciate that. I'm playing catch up. My brain is not on yet. I hope you had a great weekend. I did have a pretty good weekend overall, Barbara. We made a good dinner last night. Go back to the pre-show, check it out. I got a couple of picks. But thank you so much again.
Good morning, you're Tashawn Bass. And Mr. Bass, this is your initial appearance in each of your cases. Cause number 25, DCCR 0832 and 0833. You're charged with aggravated sexual assault of a child from March 14th of 2023 and June 1st of 2024. Since you've made bond in your cases, have you had an opportunity to try to hire a lawyer? So what I'm going to do, Mr. Bass, is reset your case about 30 days. Let's see. So this is one. You were certified as a juvenile, is that correct? Did you go through family court stuff first? Juvenile? Okay. All right, so I'm gonna reset your case. How old are you now? 18. Are you working? Why not? Okay. Give me just a second. You're not still living at the same place with the complaining witness, right? Yeah. Okay, so what I'm gonna do this morning is appoint you an attorney, Mr. Bass. Okay, so you'll keep Mr. Rojas as your attorney. No, he's not here yet, but step in front of the clerk. She'll give you his information and when you need to contact him, okay? Brandell Griffin.
Hello.
Good morning. You're Brandell Griffin. And Mr. Griffin, did you talk to some attorneys or get someone hired?
I talked to 3 more. I couldn't get no one hired.
All right, who'd you talk to?
Judge Walker, my son Kyle, son Hector, and Crenshaw.
Okay, thank you for taking care of that, Mr. Griffin. I'm going to have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. You need to make sure you fill it out accurately and completely because you're going to swear under oath that it's all true and correct. If you'll step to the clerk on the end, she'll give you that paperwork.
Barbara, thank you for gifting 5 memberships. Very generous this morning. I surely appreciate that. I really do. By the way, that merch that you're looking for, I am still working on that. So hang tight. I'm getting closer. I just want it to be right.
You don't have anything on him? Call or anything? No response, John? Let's see, I'm gonna, we haven't heard from him. I think what I'm gonna do, just based on the weather, is reset it 1 week instead of forfeiting the bond. So Kelvin Johnson will reset 1 week. Anthony McFarland, oh, hi. You're so sneaky.
I know, I am conspicuous. On Ramirez, Judge, that's not a case that's gonna be dismissed for doing the class. She did complete it. Our investigator spoke with her and really doesn't think that it's a case that should be dismissed.
Okay, sounds good. I'll take care of it. Thank you, Mr. Nichols. No response on Anthony McFarland? I'm going to do the same thing on that case and reset it 1 week. Mr. Ramirez, come back up, sir. So, Mr. Ramirez, the investigator has spoken with the complaining witness, and even though she's taken that class, they are not inclined to dismiss the case. So what that means is you're going to need to get you an attorney. So I'll reset your case for about 30 days to give you some time to get a lawyer hired. If you get someone hired before the next court date, bring the reset notice that you get to them. They'll tell you what to do. If you're unable to hire someone before that next court date, then I'm ordering you to visit with at least 3 lawyers and then bring me their names so I know you're trying and we'll discuss options. Okay, step in front of the clerk.
So I've got my eyes on a bunch of different courtrooms across the country. It's kind of a mixed bag this morning. Some of it's probably weather related. A lot of people not showing up. Some courts that are usually running aren't quite going yet. I'm going to hang with Judge West here for just a little bit. It looks like they're queuing up some stuff in Judge Collada's court. So barring something else, we'll probably go there in the next few minutes.
I know, Ms. Walker, 25 DCCR 1212.
I've seen him. Kyle just called him to make sure everything's okay.
Okay.
So if I could just have a couple of minutes.
Yeah.
I think we're gonna get.
Okay.
Get this worked out.
Let me go ahead. Would you call his name, please? David Biano.
That's a lot of years of me standing here in front of one of you.
I know.
That's why I got out of the jury box. I wasn't comfortable over.
I know.
I didn't want to be drug tested.
You never know what happens when you get when you're sitting over there.
Ask me.
You know, yeah.
Justify.
No response, John? I'll hold it while y'all check into that.
Thank you.
Sure. See, Mr. Morian, you have Carolyn Whitaker.
Yes, Your Honor.
2 cases. I saw him just walk in.
He was walking in to walk back to the back. The weather here is not near as bad as it was in Jasper.
No, it's not, and you could have called because
Oh, it could have been. No, the roads were great.
they were fine.
Oh, they were perfect. I drive a 1-ton anyway, so I mean,
You're gonna.
yeah, I'm all right. Got to justify having that thing.
We could have had you pick up some others and bring them down on your way.
I try to keep it to where if I don't show up,
Something's bad.
Something is bad wrong. You know.
Did we lose him?
Yeah, I felt bad. I texted Tom Kelly this morning. I said, hey, he said, I don't know if I'm clear. I said, I'm rolling.
Yeah, we got our county did. I'll hold it for just a minute. Let me hold it. Mr. Macon, you've got Bethany Loza Diaz. It's a sentencing. This is Mr. Hoffpower's sentencing. It's agreed. If somebody could.
I'll step in, Your Honor.
Thank you, Mr. Nichols. All right, ma'am, you are Bethany Loza Diaz. And Ms. Loza Diaz was previously in court, entered a plea of guilty to driving while intoxicated with a child passenger. I've received that pre-sentence report. Has everyone had an opportunity to review the report?
Yes, Your Honor.
Any additions or corrections? All right, Ms. Loza Diaz, I'm going to find that you previously entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of driving while intoxicated with a child passenger, sentence you in accordance with your agreement to a term of 2 years in the state jail prison, but probate that for 5 years. You're ordered to pay a $1,000 fine and to follow all of the rules and conditions of probation. If you do that, then for all practical purposes, your case here in court is over, and you'll be able to serve that 2-year sentence while you're out on probation. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, and then you could go to the state jail prison for up to for that 2 years you've already agreed to. Do you understand? I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Macon. All right, ma'am, if you'll just have a seat here in the courtroom, probation will call you up to her desk when she's ready to go over your paperwork. Good luck to you. Mr. Paget, you have Catherine Castillo sentencing. Castillo. Oh, yeah. Yeah.
Trinity Bell.
She went out to check on her. She's normally here on this. How are you this morning?
Good, how are you?
Good. Oh, here you go. Okay, I was about to say, she's not one I worry about. Good morning.
So, good morning, you're Catherine Castillo? So before we go further, when I was reviewing the pre-sentence report, there's a new, or another, driving while intoxicated from July of 2025. Ms. Werner contacted your office, I think, and they contacted the lab. It was waiting on lab. They've pulled the case, and the evidence is going to get tested in the next batch, whatever that means. And so I guess I'm wondering what the plan is on that case. If we need to wait for sentencing on this, if
It may be better.
it obviously gives me some concern that she was on bond for one and
I'm not opposed to that.
got arrested for another.
And it'd also be another felony.
Yeah,
Obviously, so,
yeah. So do you have the auto ignition interlock device on your vehicle?
I do.
You don't? Are you driving?
No, my niece is driving.
Do you have a car? Do you ever
No,
drive?
I do.
Okay, you cannot, a condition of your bond already is, if you're not aware, you should be. But if you're not, then you cannot drive any vehicle that does not have that auto ignition interlock device on it. I feel like I think I want a SCRAM device.
And that was a suggestion that Mr. Smith had noted on his PSI as
Yeah.
well, Judge.
I realize that both of those things are probably,
She does work full-time, but the only thing I would be concerned about is the finances, but
I mean, it's a requirement to have the auto ignition interlock
Understood.
by law, but I want proof that you have that on your car this week. If you need to get it on your car, you need to send proof that you have it installed to Mr. Paget.
And then I'll-
If I don't have proof of that by, let's say, Wednesday at 5 o'clock, then there will be an order, number one, that you don't drive, and number two, that you wear a SCRAM device. So I want proof of that by Wednesday, okay? All right, we're gonna hold this because Ms. Werner contacted your office, and they contacted the lab, and there's a new case, and they're gonna have it tested with the next batch.
New DWI?
Yeah.
Yes.
I mean, it's in the PSI.
That's the first place I saw it.
Yeah.
First I knew of it, actually.
Yeah, all right. Y'all, you're excused.
Thank you, Your Honor. I
Thank
appreciate
you.
it. Thank you, ladies. Have a good day.
All right, friends, let's change it up. New contestant up with Judge Collada in Lake County, Ohio. Let's go there.
Thank you, Your Honor. It pleased the court, we're before the court this morning in the matter of the State of Ohio versus Martin Martinez, case number 25 CR 1102. The defendant is present in the courtroom with his attorney, Mr. John Fatica. We're before the court this morning for purposes of sentencing the defendant having pleaded guilty and been found guilty of one count, theft, a felony of the 5th degree. Parties are ready to go forward, Your Honor.
Thank you, Mr. Fatica. Any reason not to go forward with sentencing?
No, Your Honor.
Anything you want to say on behalf of your client?
Your Honor, I'd like to start off by saying that Mr. Martinez understands he used very poor judgment not to show for his PSR. He did turn himself in voluntarily. 34 years old. He's currently employed as a laborer for Deck Rescue. He has 6 children. The youngest of his children, both under 2 years of age, live with him and his fiance. He has 16 days of jail credit as of today.
How many?
16.
16. I thought you said 60.
No. We've submitted a number of letters that demonstrate that he has a supportive family and friends. He's been active in AA. He's been a sponsor in the past. He relapsed here. And again, we understand that the court's options are limited, but we'd ask for leniency. Thank you.
Mr. Martinez, you have the right to address the court before you're sentenced. You can say anything you want. Is there anything you want to say at this time?
Yeah, I wanted to apologize to the victims. I know they're not here. Mike and Anna were very kind to me in my life and provided me with an opportunity when I was in early recovery several years ago. I don't know where things went wrong, and I don't have an excuse for what I did for them. And I hope I can make restitution and a personal amends to them. I'd also like to apologize to my family sitting over there. They've stood by my side for 20 years of addiction. And even with the good years, I know there's always that anxiety of the next relapse. And I just love you and thank you for always being there for me. I'd like to address to you, I'm sorry I didn't show up. I wasn't in my right mind. And I just want to put this behind me. That's it.
Fatica, anything else on behalf of the defense?
No, thank you, Your Honor.
Mr. DePiro for the state of Ohio.
Thank you, Your Honor. You know, Mr. and Mrs. Day are not here today, but I'll tell you, Mr. Day was here the last time we had a sentencing set in this matter. He sat in that hallway and he waited patiently to express to the court how the defendant's actions have hurt he himself and his wife and his business. The amount of restitution here is $6,006.07.
$6,006?
Yes. That's what we can show. That doesn't include the times that the defendant is seen on video reaching his hand into the shared tip jar and taking cash. That also doesn't additional conduct that the Days just simply didn't have time to scrutinize. The Days were very active and helpful in submitting documentation of the theft to the Mentor Police Department, Your Honor. And Mr. Day put together a spreadsheet that delineated every single time that the defendant stole from them. There's 188 entries in those months of time. And every single one, the Days looked at the video, documented it, wrote it down, so that we could prove that the defendant stole this money, which was not an easy task. And that took a lot of effort on their part. Over and above being victimized by the theft, they had to do all that. Mrs. Day confided in me that they had a prior incident with the defendant where he was stealing from them, but they gave them another chance because the Days know that the defendant has children to support and they did not want the defendant's children to suffer. And he just talked them into that he's a decent guy and that he should get another chance. Mrs. Day feels very strongly that that's not the case, that this is not a situation of a good guy with a drug problem. This is sustained criminal conduct that hurt them and is worthy of incarceration and punishment. The defendant does have credit for 16 days. Thank you.
Thank you. This court has considered the facts and circumstances of the offense involved and nature of the offense. I don't have a pre-sentence report to consider because the defendant failed to appear at the probation department for his interview and for the preparation of the pre-sentence report, so one was not able to be completed. I did receive a victim impact statement, and I've read and considered what the victims have had to say. I received multiple letters in support of the defendant from family members, acquaintances, and I've read all of those and taken those into consideration. I've considered what's been said here today by the defendant himself, his lawyer, the prosecutor. All this is considered by the court and by the purposes and principles of felony sentencing set forth in 29-29-11. For the factors in 29-29-12, the court finds in regards to the factors that make the offense more or less serious. That the victims in this case not only suffered serious economic harm, but also emotional harm. They entrusted the defendant, and he violated that trust. The economic harm, as alluded to by the prosecutor, is not the only loss they had. They spent hours and hours putting stuff together and researching and investigating what happened here. The defendant's relationship with the victim facilitated the offense. The defendant had a position of trust with the victims in the business there and used that position of trust to commit this crime. No factors indicate that the offense is less serious than normal. You know, this took place over a 7-month period of time. This wasn't just a one-time incident that occurred, which is what most offenses are. This was 7 months of planning and scheming. Every time money is taken, it's a crime itself. It's planned out and it's schemed, and the cover-up has to be involved. And he did this over and over and over, 180 some times in minimum. And they trusted you. They helped you. They gave you advances on your pay every paycheck almost. Because you talked about how you were in financial need and dire straits and you had kids to support. And they went out of their way to help you. And that's how you treated them. No factors, again, make this less serious. As for recidivism factors, the court notes that the defendant has a drug abuse problem. I don't know if it relates to the offense or not. But he hasn't done anything to address it. 20 years. I think one letter mentioned 18-year opioid addiction. He mentioned 20. He hasn't done anything to address it. He violated the conditions of his bond in using drugs while on bond. and failing to appear for the probation department, failing to appear for his sentencing, even though he turned himself later in that day. He wasn't here for his sentencing. Factors indicating recidivism is less likely if the defendant doesn't have any criminal history. He's led a law-abiding life for a significant number of years. In terms of any convictions, he's been using drugs for 20 years. And obviously that's against the law, but he hasn't been convicted of any offenses with that. The problem here is that you didn't show up for your pre-sentence report. And you were specifically advised when we were here last time that in order to be considered for probation, a pre-sentence investigation had to be completed. And in order for a pre-sentence investigation to be completed, an interview with you had to take place. And you were specifically told if you fail to show up for that interview, probation cannot complete a report, and the court doesn't even have the lawful authority to put you on probation. And you were also told that if you, the court will not continue the sentencing to some later day to get the report done because it wasn't completed initially due to your lack of cooperation. And you even mentioned about how you had used shortly before that. And I specifically even told you, I watched the video before I came out here at the last hearing. I go, even if you're afraid of being arrested, you need to show up. It's important to show up no matter what. And you didn't show up. So I can't put you on probation. I don't have the authority to do it. And you were specifically told that. And you made that conscious decision not to do it, not to come in. And even in this case, you were supposed to show up on December 22nd. You didn't show up to probation. They contacted you and they spoke to you. And they rescheduled it after the holiday. So if you would have gone on the 22nd, you would have been arrested. Wouldn't have been able to spend the holiday with your kids. But they let you then give you another week. To December 29th. So if there was a warrant out for you, you could have been home with your kids for the holiday and still gotten your pre-sentence report done. Now, they didn't ask me about that beforehand. I don't know if I would have allowed it, but they allowed it. And you didn't show up on December 29th. So when you talk about wanting to spend holidays with family and kids, there may be something to that. But then December 29th rolls around after the holidays and you still don't show up. And December 30th and January 1st and January 3rd, you don't show up. That's a decision you made. Knowing the consequences, that's a decision you made. So there's nothing I can do about it. I'm not going to continue the sentencing to a later day to get a report done because you chose not to. You don't want a report. It's the only thing I can assume. I've been doing this for 22 years, and I've done that all the time when people don't show up. And there's no reason to create some exception in this particular case. So you violate the conditions of your bond. Prison's consistent with the purposes and principles of sentencing. And if you can't show up to the probation for a simple interview, I can't find you're amenable to probation. I mean, that's one of the basic conditions is you have to report to your probation officer, aside from whatever other conditions have to be followed. You can't use drugs. You use drugs. When you turned yourself in, you're positive for cocaine, marijuana, and fentanyl. So you're using this whole time you were out.
I have a drug problem.
So violate the conditions of his bond. Prison's consistent with the purposes and principles of sentencing. Again, the defendant is not amenable to any available community control sanctions. You know, the offense here, it's not just a possession, a drug charge. You stole from people over a 7-month period of time, thousands of dollars. There deserves to be consequences. Therefore, as a sentence to this court that in count 1, defendant serve a term in prison of 9 months. He has credit for 16 days he's already served. I need to advise you upon your release, you could be placed on post-release control for up to 2 years. If you are on post-release control and you violate any of those conditions, the parole authority can return you to prison as punishment for violating their rules for another 4.5 months, the maximum being 50% of the prison term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. Court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control. Defendant's ordered to pay all costs. Defendant's further ordered to pay restitution to the victims in the amount of $6,006.07 to be reduced by any amount that the victims may receive from insurance proceeds. So I know a claim was made. It hadn't been resolved by the time of the victim impact statement. At a minimum, it'll be a $1,000 deductible. But I'm putting the full amount now, again, to be reduced by whatever amount is received from insurance proceeds. I think that covers everything. Mr. Tapiro, anything else for the record?
No, Your Honor. Thank you.
Mr. Fatika?
No, thank you, Your Honor.
All rise.
Okay, friends, do me a favor in the chat. What was he sentenced to? I heard the restitution amount, but I was looking at something else. So if you could fill me in on that, I'd appreciate it, because I might discuss this one in Hour 4. Speaking of Hour 4, if you're a channel member, you can join me in Hour 4. But to get that link, you need to be in our Discord server. Lily, 9 months, thank you. You need to be in our Discord server. So, Barbara, if you'd be so kind as to drop a link for that in the chat. If you're not already signed up on Discord, go there and make sure that your YouTube account is linked to your Discord account, because that's what brings over the member benefits and the member access. Anywho, let's go back to Judge West.
Good morning. All right, this is cause numbers 24 DCCR 2182 and 2183. Ms. Whitaker is charged with aggravated sexual assault as well as injury to a child, elderly, or disabled individual. And what's the announcement?
Sexual Judge.
We're ready, Your Honor.
Second trial. I believe there was some discovery that now has been given.
Okay.
On offer, rejected the last time we were in, Judge.
And there hasn't been any change. It was a cap of 40
Yes, Your Honor.
with a dismissal in the other, correct?
Yes, Your Honor.
All right, so I will get it set on the next available trial docket, and we'll get it taken care of. Stay in touch with Mr. Morgan. He'll let you know when you need to be back and ready for trial.
Thank you, Your Honor.
Thank you.
May I be excused?
Yes, sir.
Thank
Take
you.
care. Be
Go
safe
ahead.
going back.
So that's something you don't see every day. A woman charged with sexual assault. I mean, we see it a lot with teachers with male students, but that doesn't appear to be the case here. Yeah, we'll have to keep an eye on that one. Ashley, I don't know if we got her name, but if we did, could you mark it down for me just so we can remember that? Because now I'm curious as to facts behind this one.
First up on all fours, let's crawl.
Oh my goodness.
She says she's on the move.
On the move. Things are about to get real. Ms. Malfino, on Angel Coleman, it's a sentencing. Good morning, ma'am. Are you Angel Coleman? And Ms. Coleman, you were previously in court, entered a plea of guilty to aggravated assault with a deadly weapon. I've received that pre-sentence report. Has everyone had an opportunity to review the report?
Your Honor.
Are there any additions or corrections?
None that I'm aware of, Judge.
All right, Ms. Coleman, I'm going to find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 6 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have a felony conviction on your record. And at the end of the probation, if you're successful, the case will actually be dismissed. You'll never be a convicted felon, which is huge, especially at your age. The other side of that, though, is if you violate any condition of probation, you can be brought back into court. You could be found guilty, so you would be a convicted felon, and I could sentence you to prison anywhere in the range of that punishment, which is between 2 years and up to 20 years in prison. Do you understand?
Could the court also order that $900 in restitution, please?
Any objection to that?
No, Your Honor.
Also, as a condition of your probation, you will be ordered to pay the $900 in restitution. And I want to make sure that restitution at least is paid half up front or with the fees and fines and not put off. All right, so I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You just need to have a seat here in the courtroom. Probation will call you up when she's ready to go over your paperwork. Good luck to you, ma'am. Diamond Ollie, that's a sentencing. Something's familiar about this. Somebody sent me an email.
I'm coming, Judge. I apologize.
What, you guys give me some?
No, I'm just, something's familiar. I feel like someone either sent me an email or a message.
I've been speaking with family court on this.
Maybe that's what it is. Remember.
Everything's been good, at least from the state side.
Okay.
Through
It was him.
Randy.
Yes,
Miss King
okay.
and everything, so-
Look, I knew there was something.
Everything's good. That's all you need to
That's
hear.
all I need to know.
It is. It
Okay,
has been
we're
good. Everything's
good.
good. with Miss
That's
King
what I
and
got.
all
Yeah,
that.
yes. Oh, that sounds familiar. Perfect. All right, ma'am, you're Diamond Ollie. And Ms. Ollie was previously in court, entered a plea of guilty to injury to a child. I've received that pre-sentence report. Has everyone had an opportunity to review the report?
The state has.
Are there any additions or corrections?
None more, Judge.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 5 years. You're ordered to follow all of the rules and conditions of probation, and that includes, what I'm going to order is that you can have contact with your child only as approved by CPS. So you have to follow all of their rules, the safety plan and all of that stuff. And so whatever they say is okay, I'm going to rely on them, and you will be able to do it. If they say it's okay, then you'll be able to have contact. If they say no, then it's no. All right, you understand? All right, I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation will call you up to her desk when she's ready to go over your paperwork. Good luck to you, ma'am.
No fine.
No fine.
That way, follow.
Thank you, Mr. Power. Kira Rogers.
Your Honor, we're asking for a little time on that. I have an offer for restitution, and she thinks she can be able to come up with it.
Okay. All right, so we'll just do a normal reset about 30 days. And so, Ms. Rogers, if you can come up with that before the next court date, then we'll see what takes place. If not, stay in touch with Mr. Parker, so we'll see what gets worked out on your case. Okay? You're free to go, ma'am. Caitlin Talmore, sentencing.
Did you hand me? I came in here and I had to adjust for it. I want to be here.
Hey, there was some feelings hurt. I'm just
I
saying.
came here and told Amy, she said, go. She told me not to run. Talmore.
Caitlin Talmore.
Hey, George was all warm last night, but he's all snuggled up in that blanket I gave him.
There he is.
Socks, blanket, what else?
And the onesie?
Oh, yes.
From last year? Oh, no.
That was the warmest one, was the one.
Good morning. Are you Caitlin Talmore? And Ms. Talmore was previously in court, entered a plea of guilty to evading arrest or detention with the use of a vehicle. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Have your Honor. Yes, sir.
Are there any additions or corrections?
No worries, Judge.
And so you already are on probation for the DWI from that same date. Okay. All right, then I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 3 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. If you do all of that, this is an excellent opportunity because you do not have a felony conviction on your record. And at the end of the probation, if you successfully complete it, the case is actually dismissed. You'll never be a convicted felon. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty, so you would be a convicted felon, and sent to prison for anywhere in that range of punishment, which is between 2 years and up to 10 years. Do you understand? All right, I'm handing you the trial court certification That shows that this was an agreement that I followed, and so you've waived your right to appeal. You just need to have a seat here in the courtroom. Probation will call you up to her desk when she's ready to go over your paperwork. Good luck to you, ma'am. Thank you, Mr. Parker.
All right, let's stay in the building, but walk across the hall. Say good morning to Judge Stevens.
Saved up a substantial amount of retainer for a digital forensics expert, and I anticipate that he will be hired in the next 2 weeks. Such that what I would request is just in terms of being practical, I think
yeah, that would be a nice thing.
90 days we would be ready.
Lisa.
But by comparison to the rest of the trial docket, Judge, is relatively young, so I have no objections.
It certainly is not 4 digits old, but
no, sir. It's not even a year at this stage.
Are there any issues of conditions of release that need to be dealt with here?
I think you've done that previously, Judge, but that's
Yeah.
fine.
Remember that one.
I'm going to say no.
With this charge, my concern is involving images of people who may be close to it. That's what I'm worried about. Dealing with.
This is.
Maybe it's not. I don't know.
The only fear the state has is his internet use, is because that's the driving factor on this case. I have no evidence that it involves anybody that is close to him in relationship.
In 90 days?
Yes,
3 months?
He takes a long time. Like the expert.
Well, here's what I'm going to do. I'm going to reset it. 2 months, okay, 8 weeks, and then it'll be kind of a review.
Yeah, I would ask that so that I can determine if I need to do that.
Get a resetting. Leon Davis.
Thank you, Your Honor.
Is in custody. And again, have we heard from Mr. LeBlanc at all?
Yep. I haven't seen it.
Okay. Hector Alvarez was reset. So let me pull all of these that are going to be sets.
Yeah.
Here's Jerome Ned. And here is Hector De La Rosa. And then that was Jose De La Rosa. Hector Alvarez is this one. Who's ready on a plea? Come on. Yes, on Mr. Garcia. Mr.
Or it may take me a moment, but it's next door.
Okay.
I guess one day I'll get used to this.
You want to show a picture of his family again?
Or give you years for the number of kids he has. Yeah. That what you're asking?
Did I want to read one?
No, Jim.
You know what they say.
He and I have talked about everything in depth.
Well, they certainly were written in depth. $21,370,009 is now called. Are you Mr. Garcia? Please see that lady first. Thank you.
Press your right hand. Where are, tell the truth on the truth you got? Okay, you get your right hand. Place it up there. Ink it up one more time. Place it right there. Okay, so go sneak time touch.
I'm a long way here in this case from not being able to speak English at all to very neatly written in English, multi-page document. And you are Jonathan Garcia.
Yes.
And you speak English, correct? Is that yes or no?
Yes.
Okay. Yeah, she has to take everything we say. And this case is called 21-370.
Jill, yes, that's all.
Well, I thought she was calling it. 21-37009. You were charged with the second degree felony of aggravated assault. You understand that, sir?
Yes.
You were here with your attorney, Mr. Eckert, and the state's attorney. Does the defendant waive a formal reading of this indictment and the arraignment? Can we proceed in summary?
We do, Judge, anything.
In summary, Mr. Garcia, this indictment, it was handed up a while back in April of 21. We're going on almost 5 years now. And in summary, this states that on or about April 4th, 2021, in Jefferson County, Texas, you committed the second degree felony of aggravated assault. And it states that you intentionally and knowingly and recklessly caused bodily injury to another person with the use of a deadly weapon, namely a handgun, by shooting the complainant in the upper part of his body. Do you understand what you're charged with here?
Yes.
This is a second degree felony under state law, which means if convicted, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand the punishment range?
Yes.
Are you a United States citizen?
Sir.
You're not. Do you understand if you are not a United States citizen, a plea of guilty may result in your deportation,
Yes, sir.
exclusion from admission to the United States, or denial of naturalization under United States federal law? Do you understand the risks that you take?
Yes.
Okay. An agreement has been reached in your case where you would be pleading guilty, sentenced to 6 years in prison. You will be given credit for all time you have served in accordance with this case. Is that your understanding of the plan? If I follow this agreement, sir, you have no right of appeal of your case. Do you understand?
Yes.
Today is January 26, 26.
Yes, sir.
How do you plead, sir, to this charge, the second degree felony of aggravated assault in this indictment? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty of what this states?
Yes.
I'm going to show you with your attorney what is marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it, discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No objection.
And without objection, it is admitted. Among other things, this states that you are mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer in this case. All of this is true, it states. So help you God. Correct. All right, your State's Exhibit 1 is made a part of the record without objection.
Without objection, Judge.
It is so done. Pre-sentence report is waived here.
Yes, sir.
If nothing further to add, I am going to follow this agreement that has been reached here, Mr. Garcia. I'm going to find that you are mentally competent to enter your guilty plea. It is freely and voluntarily made. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 here, admitted to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of the second-degree felony of aggravated assault. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 6 years. Additionally, the court is going to make a finding that based upon the allegations in the indictment for what the defendant has pleaded guilty to, a deadly weapon, namely a handgun, was used in the commission of this offense, and it will be so rendered as an affirmative finding on the judgment. Do you understand what has happened today, sir?
Yes, sir.
Okay. Stand by just 1 minute, please. Let me just look one thing. You have a family, where?
Arlington, Texas.
Argentina?
Arlington.
His wife and children live in Arlington, Texas.
Oh, Arlington.
She is a United States resident.
So why were you here in Beaumont, Jefferson County? Why weren't you living in Arlington when this happened? You were here at work, working?
Mm.
What were you doing? What work do you do?
Construction.
Construction. He works concrete, Judge.
You know, your family is very important. This is what I'm reading here, that you say this in your letter,
Yes, sir.
and they are. That's why it's very important when you make decisions. You have to consider how that might affect the people you care for very much.
Mm.
Who wrote this letter? You've signed it. Did somebody help you write this?
Yes, ma'am.
Okay.
I'm making a find somebody from.
Okay, and they put it in English.
Right.
This is like the same letter. Just rewritten. And all right. Is there how much credit does he have?
Judge, he has about a year and 3 or 4 months, I believe.
Really?
He was on bond initially, and that bond eventually.
I was in Dallas County, waiting for.
Dallas County?
Yes, so come.
Well, you will be given credit for all of that, but because of the crime that was committed, because a deadly weapon was used, you must have credit for 1/2 of the sentence. So 1/2 of 6 years is 3. You have to get credit for 3 years. You're well toward that, but it may be a little while longer before you can be released. But I think they normally do that when it reaches that half point, that halfway at 3 years. Once you get that, they're going to get you released. Okay, take care of your family.
Thank you, Judge.
All right. Thanks. I have Andrew Kennedy. Mr. Reynolds?
He needs to be fingerprinted, Judge.
Yeah.
He'll put his nose in this.
Kennedy. Well, that one was an old one.
27 months.
Thank you.
What is he, there's three cases. What's he going to be pleading
He's going to
to?
be claimed to the sexual assault and the.
Indecency by exposure.
And then another, a third case, indecency with a child, will be dismissed.
That's correct.
Yes.
He needs to go
Oh,
in
yeah.
front of her? Okay, thank you.
Right here. Where walk up, on the street, then I took the dust up, pick up your right thumbprint. Let's it flat right there in the box. Okay, you get it one more time, same one. And flat right there. Okay, go stand in front of the judge.
And you are Andrew Kennedy, sir?
Yes, sir.
Three cases are called 1769, 1770, 1771, and in numerical sequence, 1769 alleges that you committed the second degree felony of sexual assault of a child. 1770 alleges you committed indecency with a child, and that is a second degree felony. And then a third degree felony is alleged in 1770, 1771, and that is indecency with a child in that case, and that is a third degree felony. So in the two second degree felonies, you were looking at no less than 2 nor more than 20 years confinement in prison, and in the third degree felony, that is up to 10 years in prison. So a total of 50 years in prison is at issue here in these three cases. So it's my understanding you are going to be pleading guilty to 1769 and 1771, sexual assault of a child, second degree felony, and the third degree felony of indecency with a child.
Judge, on the third degree felony, I think I checked the wrong box.
That's okay. We can fix it.
Okay.
And then in 1770, that second degree felony of indecency with a child will be dismissed as part of this agreement. Was that your understanding of the master plan, sir?
Yes.
You should. So you were here with your attorney and the state's attorney. Mr. Reynolds, does the defendant waive formal readings of these indictments and arraignments? Can we proceed in summary?
He does, and you major.
Okay. In 1769, 23 CR 1769, in summary, so this on or about December 22nd, 2022, in Jefferson County, Texas, you committed the second degree felony of sexual assault of a child. You understand what you're charged with in this case?
Yes, sir.
If convicted, you were looking at no less than 2 nor more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand the punishment range applicable?
Yes, sir.
An agreement has been reached in your case where you would be pleading guilty, sentenced to 10 years imprisonment. This would run concurrently with the 23 CR 1771 case, and 23 CR 1770 will be dismissed as part of this agreement. Is that your understanding of the agreement?
Yes, sir.
If I follow all of this, you have no right of appeal of your cases. Do you understand?
Yes, sir.
How do you plead in this case, sir? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty?
Yes, sir.
I'm going to ask the prosecutor, something happened on that. I don't know what happened there. Well, just please sign. Thank you. Somebody leave these pads out in the cold last night? But they're really acting funny.
There's a delay, I've noticed.
In 1771, sir, this indictment is a third degree felony, indecency with a child by exposure. And it was checked off as the second. I'm changing it to the third.
Yes, sir.
Which means you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand that, sir?
Yes, sir.
The agreement in this case is you would be pleading guilty, sentenced to 10 years in prison to run concurrently with the previous case that you pleaded guilty to, and then cause number 1770 will be dismissed as part of this agreement. We are getting new pads this year, right?
Text Mary Helen and ask them. We were gonna.
Because you told me that.
I'll let you
You
know.
told me that 6 months ago. All right.
I'm getting an update as we speak, Judge.
Hasn't been a year yet.
It's like Santa didn't show up for Christmas. I'm a little upset.
Well, maybe we didn't make the good list.
If I follow this agreement, sir, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead on this case, sir? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
I'm going to show you what's marked as State's Exhibit 1 for each of these two cases you have pleaded guilty for. Did you sign those documents voluntarily? Understand them, discuss them with your attorney? Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence
No objection.
without objection admitted. Among other things, this states you, in each case, State's Exhibit 1 states that you were mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read you. You read it. You are guilty of the crimes charged in any lesser included offenses. You have your rights to a jury trial, the appearance of counsel. In each of these two cases voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting a guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of each of these two cases, sir. And I'm following these agreements. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years on each of these cases. And these sentences shall run concurrently with each other. Do you understand what has occurred today, sir?
Yes.
And 23 CR 1770, that case will be dismissed as part of this agreement. Do you understand? Anything else to add on this?
He gets credit for his.
Yeah, of course he does. He gets credit for all time he has served in accordance with these cases. Also, do you understand? There are certain requirements now that you must have. You are now a sexual offender under the laws of the state of Texas, which means that you have to register as a sex offender because of each of these two cases that you have been found guilty of. Failing to register properly can result in additional felony charges being filed.
Yes, sir.
And you could be then sentenced to additional punishments for felony offenses. Please make sure that you understand the requirements and you follow them.
Yes.
Anything else to add?
No, sir.
Okay, thank you. That is all. Good luck. I'm going to also, I think there is it's a dismissal. I don't see it yet.
Well, for first time in a long time, a crime against child in front of Judge Stevens didn't get a free dinner to the Sizzler that night. So there's that. Good morning once again, everybody. TCF Live. It's Monday. Good to have you all here. I know there's a lot of new people out there this morning. Please do say hi in the chat. This is the best community in LawTube. A lot of good people here, so interact with them. You'll like it. Let's change it up. Maybe something a little lighter. Maybe Michigan. Judge Middleton.
Mr. Fletcher is in custody. Has been in custody for 38 days, according to my calculation. Prosecuting Attorney Deborah Davis is present, as well as Assistant Abby Stoll. Let's start with the Fletcher case. It is set for 10:30. Mr. Fletcher was charged with aggravated assault for an incident that occurred at Yoder's on December 19th. He's been in custody, I think, since that time. Defendant is also on probation in Cass County, and I believe was headed to the probation center. Mr. George, this is a case I think we needed some help from Pivotal or other mental health services. If I didn't call the case, it's 252602, People versus Travis Fletcher. Mr. George, what's the status here?
Thank you, Robert. I've had the opportunity to see some correspondence from Ms. Frank, who's our individual at Pivotal at the jail, as well as some conversations with my client. I think what's clear here is there is significant diagnosed mental health concerns with my client. Since he has been in custody, it's my understanding that he has been medicated. That was one that was consistent here. He did come in at the first pretrial and enter a plea of guilty to the charged offense. It's my view from talking to him, Your Honor, that this was a cry for help for him. Doesn't justify what he did, but I think it gives the court some reason why he did what he did. But anytime that anybody in the community is affected in this way, Mr. Fletcher understands that it's not acceptable. Going forward, I think there's going to have to be a significant mental health treatment component for Mr. Fletcher. Indicates that he wants to be committed to some type of facility, so he has the ability to access those resources. I think he does have concerns that when he's not in custody, whether he can access his medications that he needs. But I also at the same time understand that he is currently on MDOC probation out of Cass County. So I don't know if this court is, looking to try to put him on any type of supervision here where significant supervision over in Cass County. All in all, Your Honor, obviously this is it's not a good situation. The facts are terrible. But I would just ask the court to consider some of the mental health concerns that my client has, and we're making a determination on what's most appropriate. Thank you.
I believe I did make a referral to Ms. Frank at the jail after this plea. And I'm pleased to hear that she's doing a great job. I can't say enough good things about her. She follows up every time I ask her for help. But what's his status with Cass County? Is he still envisioned to be going to the probation center, or do we know what their plan for him is?
Your Honor, I asked him what his understanding of what Cass is going to do, and I don't know that that's clear. Based on some information, and Ms. Davis, if she has more accurate information, can correct me. But I think that there was some type of issue about there was supposed to be a hold or something that was put on the place and not released. And I'm assuming at this point that hold has been corrected. So I would imagine when this sentence is over, Cass is going to deal with it. I don't know specifically what they're going to do, but I think he's going to have to address that Cass County situation.
Yeah, as I understand it, he was improperly released from the jail, went from the jail to Yoder's where this happened. I'm not sure what the status of all that is, but Ms. Davis, you got any more enlightenment for us on this?
Maybe a little bit, Your Honor. Unfortunately, I don't have a copy of his PSI from Cass County to kind of reference like what his guidelines were and what their plan.
What was the charge?
So the charges were possession of methamphetamine and malicious destruction of fire and police property and R&O, I believe. Yes. So he was sentenced to confinement for 365 days and then a concurrent probation of 36 months. So his sentencing was in August of 25. The arrest by the Dowagiac Police Department was in February of 2025. So it appears that, from my understanding of all of these different agencies and people involved, that he completed his jail term at Cass, but was then being placed at the Twin County Probation Center. But when he got to the probation center, he said that he didn't think that this was part of the deal. He didn't want to be here, didn't want to do this. And there was some sort of commotion caused, which then caused the jail to the police to come and take him to the jail. And they notified Cass County. It's my understanding that Cass County planned to come over and get him and take him back to Cass County, but there was some sort of confusion with paperwork being faxed over ahead of time, and they released him before Cass County got there to pick him up, which is what led to, yes, him walking through the village of Centerville, looking for a ride in the Dollar General and not getting one, and going into Yoder's and doing what he did. I understand that mental health obviously is an issue. However, you know, these are things that he lied to the officer and said he tripped. And then we have very good video showing that he did not, in fact, trip. This family, mother and the two children, are extremely traumatized over this. Thankfully, there was a lot of people around. Standard by, like, went and chased him, and they had a good description of him, and he was able to be picked up. But that doesn't cure the issues here. I'm hopeful that Cass County has a straddle cell prison time waiting for him, because he's not safe to be out in the community, obviously. Whether mental health issues or drug issues or a combination thereof, we have serious concerns, and we would ask for the full year in jail for this. The victim would like to speak. She obviously is shaken up over all of this. Other than that, we would ask the court.
You want to hold him in our jail for a year before Cass County does their potential prison commitment?
I don't necessarily want to hold him here for the year, but if he's sentenced, then I can guarantee that he's going to be either here or MDOC. I don't know what Cass County might do on the PV, but I mean,
well, the problem is nobody asked. I was hoping maybe somebody would have talked to Cass County and said, what's the plan here? But we don't know that. But certainly this is a scary circumstance.
And I've been in contact with Cass County since the day this happened. So they are aware of what happened. They were aware of what the bond was set at, and my concerns that if he were to somehow post bond, to make sure that they had their hold in place. So I've not heard back.
So do we believe the Cass County hold is in place?
I'm not sure. They haven't returned my calls.
You're nodding your head. Do you have some knowledge about this?
Say again, Ron?
Hello, Deputy Studebaker. Judge Middleton calling from the bench. Does Cass County have a hold on Travis Devon Fletcher? What was the date of that? All right, what was the date of the most recent detainer? All right, thank you. Bye. He was supposed to have the detainer as of December 18th, but apparently something happened and he got rearrested. And according to Deputy Studebaker, Cass County placed a detainer on him, a probation detainer on December 19th. So there is currently a detainer for Cass County. So if he were to postpone, he would go to Cass County.
And Your Honor, part of the request for a significant amount of jail time is based on the unknown for Cass County. If he's used up all of his local time, so Cass County probation violation, if they go forward with it, it's either nothing and you continue on probation or you go to DOC. Those are the two options, it appears. And my concern is that if they choose to not send him to DOC and he's just released on probation, that would be a disservice to our community. So also there is restitution that is being requested. However, it's a significant amount of medical bills and the victim does not have everything in order.
All I saw was the $50
That was her vest.
vest.
Yes.
Is
So-
there more?
Yes, she had to go to the hospital. She had CT scan. Her knee is injured from it. So there's a significant amount of medical that will be coming. Obviously, those aren't.
But we don't have that yet.
No, she's working on getting the information from the hospital. She went to Three Rivers Health for those tests.
Have they submitted a crime victims' rights claim on her behalf?
I don't know.
Somebody's
Yeah, I was
busting
gonna say,
out of the
somebody's
flooded
busting
back
out
room.
the back room.
They're probably working on it.
I don't know if they have or not. We can certainly explore that. And obviously with the defendant's situation, getting restitution from him, it's going to be very difficult. But we would just ask that restitution be reserved
Okay.
on that.
And your complainant wishes to speak. Ms.
Yes.
Morrissey, would you come forward?
They have her sit at night.
Yeah, that'd be fine. Good morning. Would you state your name for the record, please?
Mercy,
Could you spell your last name?
MORRISSEY.
All right. What would you like me to know?
It was Thursday afternoon, about 4:30 p.m. And my two girls and I were heading to Sturgis for my oldest tumbling practice. They talked me into stopping for donuts at Yoder's, which we've done a few times before. It's a few days before Christmas, so we say hello and Merry Christmas to the Salvation Army bell ringer outside. Upon entering the store, we see their 12 Days of Christmas giveaway, and I fill out a piece of paper to enter. The girls notice that they have an elf hidden somewhere in the store, so as we make our way over to the bakery side for donuts, they are looking for the hidden elf. My girls decide on a donut to share, and I grab a box to fill. I set the box down briefly and put on the provided plastic food gloves and get ready to open the first case to get their donut. As I'm putting on the glove, I am shoved into the glass donut case and see glass shatter in front of my face. In the time it takes to be body slammed into the case and for me to turn around, I see a man running for the door and yelling as he exits. I stand there in disbelief for a moment and see my bleeding hands cut from the glass. I quickly ask my girls if they are okay. They are silent, but manage to tell me they are physically okay. A male customer approaches me and asks if I know that guy, and I say no, I've never seen him before in my life. This kind man then takes off running after the man who just shoved me. Another customer, a female, and 2 employees tend to my care. One asked, "Do you want me to call 911?" and my response was, "Yes, please." The customer and other employee took me and my girls into a bathroom around the corner to help clean me up as we waited for the police and the EMTs. I'm in utter shock, confusion, and just running on adrenaline. I must have asked my girls if they were sure they weren't hit about 50 times. My oldest, only 8, I'm so incredibly proud of her. We've practiced making emergency calls before, but thankfully never had to utilize it until this day. I instructed her to call Daddy and my mom. She was so calm and relayed the necessary information to both. I fully believe her staying calm helped her younger sister, only 6, to also stay calm. This in turn helped me. I get my hands all cleaned and bandaged up and head back out to the main bakery area to wait for anyone to arrive. At this point, I've noticed that the vest I was wearing was ripped in a couple places from the impact, and my knees are really starting to bother me. My mom arrives first, and I have a brief moment of relief and cry as I hug her as she takes my babies away from the area. Then the police arrived and told me that the man had already been detained thanks to the description given by the employee through dispatch and the customer who went after him. He claims he tripped, and I guess that's what he yelled as he ran away. The employee was phenomenal in making sure I'm okay and providing her witness statement and guiding officers to view the surveillance. EMTs arrived and brought me outside to check me out. It's starting to rain outside, and I'm still running on adrenaline. Prior to them arriving, I had my daughter take photos of my face and shoulder, which are both red from impact. The police climb aboard the ambulance and do the same, as well as photograph my hands and knees. I'm shaking as I sit in the ambulance when my husband finally arrives, having to leave in the middle of work. We decided to go to the hospital ourselves and not take up an ambulance for someone who might really need it, as I'm able to walk, though with a lot of pain. I say goodbye to my mom and babies, and off to the hospital I go. I had to sit for a couple hours in the waiting room before being taken back to a room. As I sat, my head began pounding, and I had to ask for some pain medication. My knees are throbbing as I sit in a wheelchair and I asked for an ice pack. I received both, and to just touch the ice gently to my knee was excruciating. Once back in a room, I've now had to explain my situation for the 5th time. My husband and I are sitting in our room, and I'm just trying to deep breathe through the pain and the thoughts of what just unfolded hours ago. I'm sent back for a head CT due to the impact of my face, and x-rays for both of my knees clear, and I just need all these cuts and bruises to heal. Once I finally make it home to my babies, now 11:30 p.m., and send my mom home, the toll on my children begins. The whole time I'm at the hospital, my mom is with them, and I keep asking if I'm okay. I chat with them briefly on the phone to help calm their nerves, while also helping calm mine. But what's home is where it really begins. The nightmares, causing both my children to have to sleep with me at night. Me holding them tight as they tell me it was very scary. The emotional toll really doesn't hit me until the next morning. Being pregnant twice before, never have I ever experienced so many emotions or the amount of crying. My youngest looks like she's seen a ghost and starts acting out. Her being fixated on something so much she's in full tantrum and hysterics if she doesn't get her way. When I finally get her calmed down and figured out it has nothing to do with what she's fixated on, she tells me I don't want it to happen again. I'd gone to the salon where my mom works to get a pedicure because I needed something normal and just for me. Knowing my mom was there was comforting. I didn't feel like I could be alone, and I still don't. My husband takes the children to the store after dropping me off to get the groceries we were unable to get the night before. Once home, my youngest tells me she saw a man that looked like him, and I don't want it to happen again. Knowing what she meant by this, she must have seen an African-American man, as that's who assaulted me. Being a Christian woman and a homeschooling mom, I've taught my children that God says there's only one race, the human race. I had to be mom and talk about how we know there are bad people in the world, and some of those bad people want to hurt us. That's why we stay close to mommy when out. But there are also more good people within the world, like those that helped us that night. And while I can't say it'll never happen, we have to always choose to see the good in people because that's what God wants. The nightmares continue for my children and myself. Being so close to Christmas, I'm not now looking forward to it, but I have to for my children. While I'm currently scared to be alone, loud noises scared me. Someone coming up from behind me just to check on me makes me jump. I can't let this man control my life. I'm a mom, and for that reason, I feel like I'm carrying 3 times the weight of emotions and trauma as my kids were involved. Christmas with family afterwards is something I wasn't prepared for. I feel as if he took my independence and sense of security away. I've sought guidance from a counselor to help me process the events and to help my children heal. The 2 things she suggested I do with my girls are 1, ask them what was the worst thing that happened, and 2, picture a pie. It has 8 slices. We'll call this the responsibility pie. How many pieces of pie does each person or persons get? Who is to blame or responsible for what happened? Mom, you, sister, or the man? Both of my children answered the same for both when sitting down separately with myself and my husband. The glass breaking was the worst part because it hurt mommy, and the man gets all 8 pieces of the pie. And my youngest clearly saw more than what she claims, as she gave me a complete description of what the man was wearing. My oldest remembers a black blur because it was so fast. Images they will never be able to get out of their heads at just 8 and 6 years old. While my face is finally healed, the knot on my bruised shoulder still remains, which after returning to the doctor for a checkup, shows the knot is actually a hematoma that's formed. My thigh and left knee bruising are fading, and while my right knee remains the worst from the impact, my hands still bear cuts, and I'm reminded every day of the horrific trauma we experienced while just minding our business. The bruises and cuts will heal, but the scar that's been left in my heart is permanent. I'm a strong woman and will overcome this. I have to for my girls. I won't let him get away with stealing my independence or security. I'm labeled now as a victim, but I choose to be a survivor. I've told my girls that jail is grown-up timeout for when grown-ups do something wrong and need to be punished. We're resting easier at night knowing he is where he should be and not harming anyone else. My youngest says, I hope he's in timeout for a long time, and if it's his birthday, that they don't give him any birthday cake or ice cream as punishment. I can't imagine letting someone out into our world who would go around and assault another human being, let alone a mother and her children, for no apparent reason. I feel safer knowing he's locked up and hopefully remains there for a long time. As I sit here now, a month after the incident, I'm just now starting to feel comfortable with going out by myself or with my children again. I was finally able to allow a friend to give me a quick hug, something I have been guarded against. The idea of physical contact or being surrounded by others makes me nervous, even if those people are friends or family. My injuries are fading, though my right knee now requires physical therapy. I'm hoping that today allows me to feel as though I can breathe again and a weight has been lifted. Only time will tell. I'm a Christian woman, so therefore I don't wish ill will on anyone. However, I also believe in justice to the full extent of the law and pray that this man receives no leniency on the punishment for his crime and that he gets help as a result of his actions. Whatever his claim for his reasoning is no excuse for the torment and random act of violence he carried out. Thank you.
Thank you. Mr. Fletcher, you got to hear live and in person what this incident affected on this woman and her family. I did make a referral on the day of your plea, January 2nd, to our local Pivotal. Have you been in contact with Lauren and working with the people at Pivotal here in St. Joseph County?
I've talked to her, but we didn't really talk.
All right, apparently didn't see much. In my notes, I said we need police report, victim input, and input from the Cass County Department of Corrections. We got the first two, but we don't know what Cass County has in mind. Mr. Fletcher, this is your opportunity to say anything you want me to know. Anything you want to say?
I apologize. I know apologies, sometimes aren't accepted. I just want to let you know that I'm still sorry.
Well, that's a start.
I don't know exactly what happened there because of my mental health issues.
At the first opportunity with a lawyer, you did accept responsibility for it. The charge is aggravated assault. Assault comes in different varieties, from assault and battery up to first-degree murder. Aggravated assault is a misdemeanor. It's punishable by up to a year in jail and a fine of up to $1,000. That charge closely fits these facts. It's an injury that requires medical treatment, but it did not involve a weapon and did not involve intent to commit great bodily harm. So the charge fits what I understand the facts to be. And there's a dilemma here. I think I canceled the defendant's bond at the time of his plea. He's been in jail now for 38 days. He's on probation on a felony charge in Cass County. They gave him 365 days in the county jail, which is the most you can do on a felony charge. Anything over 365 days requires a prison sentence. They also then put him on probation. And apparently he was going to go finish out his probation for a term at the Twin County Community Probation Center in Three Rivers. The Twin Counties are Cass and St. Joe County. Started that program jointly almost 50 years ago. We now take inmates and defendants from a number of counties, but it's a Cass St. Joseph County thing. I don't know what happened. The ball got dropped. The defendant got released from the jail, which never should have happened, and now we're seeing the consequence to this lady and her family. It's a strange kind of offense. There's a mental health component to it, to be sure. I don't think no insanity or diminished capacity defense has been raised. The defendant simply accepted responsibility. So all that Cass County has left is either, as Ms. Davis says, to kick him off probation or to institute a prison sentence. Hopefully, if someone commits a aggravated assault while they're on a felony probation, that should be basis for a probation violation. But nobody ever asked. My fear is if I grant 365 days, they may just call it good and discharge him from probation. At that point, there'd be no additional supervision. But we don't know. If I gave him time served, they would be compelled to do something. I would rather he was on some sort of continued supervision in Cass County, but we don't know the answer to that. My fear, as I said, if I simply grant 365 days in jail, he'll do 300 days minus 38, and then he'll be out without any supervision. And there's no sense for me to put him on probation because I would have used up every available day of jail. So I'm gonna try this. I'm gonna do 100 days jail, credit 38, leaving 62 days to serve, may be released to Cass County Department of Corrections. I'll put to Cass County on detainer. Fine is 0. I referred him for mental health services, and apparently he didn't avail himself of it much. $125 in costs, which are required, or 2 additional days, and I'll reserve as Ms. Davis requested on restitution. Mr. Fletcher, have you heard anything from your probation agent since you've been arrested? This gives them 62 days to do something. As I said, even in the world we're in, I hope an offense like this would warrant a probation violation. Now, what you point out is the randomness of the world we live in. You live in a community that we like and we consider it to be safe. Yoder's might be our favorite place anywhere. If you think of a safe place, that would be it. You're in there on a Thursday with your kids, nothing unusual. Mistakes were made and a lightning bolt strikes and you get shoved through a plate glass cabinet. I've been there. I know exactly where this took place. I guess we're all subject to the vagaries of randomness. You didn't deserve this, and I hope you can get some healing from this. He wasn't mad at you. This was not focused on you. You were in the wrong place at the wrong time. And the only way we can avoid that is to never go anywhere or never do anything. You're going to continue to live your life and do things with your kids and have a family. You can't never go anywhere or never do anything. Mr. Fletcher, you need some significant mental health intervention. I tried to start some and you weren't interested. The probation center, if they hadn't accidentally let you out of jail, might have been a good start for some of that. At any rate, that's my sentence. 100 days, credit 38, leaving 62 days, $125 in fines and costs, or 2 additional days. And you may be released to Cass County on their detainer if they so elect. All right, sir, you can go with the court officer.
Thank you.
Thank you.
I did get a text during the hearing from Victor Fitz, and he's checking what Cass is going to do.
Okay.
We'll follow up. So, thank you.
All right, thank you.
So that's something we do not see in Judge Middleton's court every day, a serious crime, a victim impact that's quite that impactful. Just not stuff we normally see there. So I just pulled this from the interwebs. This is a picture inside of Yoder's in Centerville. Looks like a cool store. To be honest, in all the time that I lived in Michigan, I've never been there. But next time I go up to Michigan, I think we'll take a look. Barbara asks, what did he get? He got 100 days to serve, credit 38, and he's got something else going on in Cass County where this might have violated that probation. So judge gave permission for Cass County to come and get him. And, yeah, that's kind of where that stands. So that's what's going on there. That's what Yoder's looks like, if you're curious. I'm going to have more to say on this in hour 4, I'm sure. And yeah. All right. Just shaking my head here a little bit. Let's go to, let's go back to Judge Stevens in Texas.
039 is now called the State of Texas versus Romeo Williams. Is that you, sir? Yes, you have to speak out so she can. Yes. Okay. Mr. Burbank is here representing you. The state's attorney is here. Does the defendant waive a formal reading of this indictment and arraignment? Can we proceed in summary?
He does, and you may, Your Honor.
In summary, this indictment alleges that on or about June 6, 2023, in Jefferson County, Texas, you committed the 3rd-degree felony of unlawful possession of a firearm by a felon. Do you understand what you're charged with here, sir? Yes, sir. Okay. It's a 3rd-degree felony, which means you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand? Yes. An agreement's been reached in your case where you would be pleading guilty. Is this 5? Isn't it?
I thought he said.
To 10 years in length. Also, I guess regular probation is an option as well. You could be sentenced to no less than 2 nor more than 5 years confinement in prison, and that could be suspended and you could be placed on regular probation. Do you understand your options here? If I follow this agreement, sir, you have no right of appeal. Make sure you speak out so she can, the court reporter can take, they have trouble on nods. And all right, again, you, if I follow this, you have no right of appeal. How do you plead to this charge, sir? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily?
Yes, sir.
That is on your own free will.
Yes, sir.
And because you are guilty.
Yes, sir.
Okay, I'm going to show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney. Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence without objection.
No objection.
Admitted. Among other things, this states you are mentally competent to enter your guilty plea as freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God. State's Exhibit 1 is part of the record for all purposes. Pre-sentence report will be prepared.
Yes, sir.
And we will come back another time and everybody will add whatever else you want to add to the record, and then the court will make its decision. Please get a resetting from that lady. Thank you.
Maybe excuse that.
And the probation office is going to be contacting you. Make sure you participate with them and give them all the information they need, sir. Thank you.
See the probation officer.
Here it says, thank you.
All right, well, they rack up the next contestant. Let's go across the hall. Judge West.
Good morning. Good morning. You're Davin Kalina?
Yes, ma'am.
And this is 24 DCCR 2432. Mr. Kalina is charged with injury to a child, elderly, or disabled individual. And what is the announcement?
Your Honor, I filed a letter of representation to join as co-counsel with Mr. Cat. Either late December, early January, I don't remember the exact date. I knew when I filed that letter that the last time everybody was here that the court had advised that that would be the last reset. In the last couple of weeks, I've had a number of conversations with Ms. Molfino. I think we've made a little bit of progress in those conversations, and I think we're perhaps closer to a resolution than we were at the last setting. So I'm not asking the court to break its own rule about what the last reset was.
No, and I don't have that it was, I don't have that it was a final one. I think it was just getting there. And so I will give you one normal reset, but y'all need to get it figured out before then. It looks like Mr. Cat's been on since July of last year, so that's kind of what I base it on. Good.
And I've also had counsel review it as well. So I
Okay.
think if we're going to be able to reach a resolution, I think we're pretty close. And if not, it would be very easy to get.
Okay, Mr. Kalina, stay in touch with Mr. Kelly so you can visit with him before that next court date, and we'll see if we can get an announcement then, okay? You're free to go.
Thank you.
And then you've got Ashley
She's
Sanders.
present too.
But anyway.
Yeah.
Or do you want to just go ahead and do it? She's got to go to the general.
It's set for sentencing?
No, they just did the plain papers.
Reset the whole thing, or we can put it today and then reset for a sentencing. I don't know which one. So
Oh, don't I always reset for sentencing? Y'all are confusing.
it's a
me.
state jail felony. So
Oh,
I don't know if you were. I don't know if we
let's do the plea.
do the
So
plea.
that's kind of done,
Okay.
and
then send
the
out-
incentive is to do everything she's supposed to before she comes back for sentencing. Good morning. Are you Ashley Sanders? And Ms. Sanders is charged with theft of service in cause number 24 DCCR 1650. And what is the announcement?
Your Honor, I think our last setting was late October, and the information we provided to the court was similar to what we've been providing in previous settings. There's an audit coming, and maybe one day we'll have it. My recollection is that one of the agents of the complaining witness was present in court.
He was and
Last
promised
setting.
that within a week.
Said we'd have it within a week.
He did.
It was delivered to my office, my version of it, I'm not sure it's the same as Ms. Molfino's, was delivered to my office the first week of January. I don't remember what day, the 4th or the 5th. I had a vacation letter in with the court. So
That was a long week.
It was a long week.
Okay.
My natural inclination was to file a motion to exclude and ask for the court for a hearing on that. The reason I didn't file that, one, was out of professional courtesy, because I didn't want the appearance to be that this was information that Ms. Molfino had and was just holding on, which nobody would have thought that. I just didn't want the appearance to be that. So,
I mean, there's no reason to exclude it. It's just frustrating that it took so long for you to get it.
it is, and
So what do you need now?
I'd like to ask for more time.
Well, yeah, I'm not going to make you announce today if you just got it. None of this has been y'all's fault. It is very frustrating. that a lawyer stood up and told me one thing in court and y'all one thing in court, but that's not you or you. So how much time do you need now to go through it and be ready for an announcement?
60 days. It's a banker's box of documents.
Okay, same. Okay, we'll reset it 60 days and get an announcement at that time. Thank y'all.
Thank you, Judge.
That's so frustrating. I had a feeling.
All right, let's step across the hall again. Judge Stevens, new contestant.
Yes, you need to speak out so she can hear you. You are Jermichael Phillips.
Yes, sir.
And in 24 CR 307, you were charged with a third-degree felony of evading arrest or detention with a motor vehicle. And Mr. Turk is here representing you today, correct?
Yes, sir.
Does the defendant waive a formal reading of this indictment and arraignment? Can we proceed in summary?
Yes, sir.
In summary, this indictment alleges that on or about January 12th, 2024 in Jefferson County, Texas, you committed this third-degree felony of evading arrest or detention with a motor vehicle. You understand what you're charged with?
Yes, sir.
There's a second paragraph that also alleges that on December 17th, 2019, in this criminal district court in cause number 19-30936, you were finally convicted of the second-degree felony of robbery. Is that true?
Yes, sir.
Paragraphs 1 and 2 would constitute a second-degree felony punishment if you were prosecuted for both of those and the jury finds those to be true beyond a reasonable doubt, which means you would be facing no less than 2 nor more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
What does this say at the bottom here? What is
It's
that?
just enhanced. It's the notation that it was, you can erase it, Judge. I just.
Okay. All right.
It's just a
Is
note.
it enhanced to second degree, right?
Yes, Judge. That was-
Okay, that's
that's
what. It was just abbreviated. and-
Yes, sir.
Yeah, I could, it looked like,
Sometimes I do what the pen allows me to do.
yeah. Like,
Oh, it's just- this one.
we all at its whim.
So if you go-
Okay, what's our plan on this?
Judge, my understanding is Mr. Phillips wishes to plead guilty, but he would like a jury to assess the punishment.
Okay, so there is no agreement.
Correct.
And he's ineligible for probation in front of a jury.
Right. Yes, Judge.
Okay. That's the way to do it. So how do you plead to this, sir, guilty or not guilty?
Yes.
Are you pleading guilty voluntarily to this third-degree felony of evading arrest or detention with a motor vehicle, as alleged in paragraph 1 of this indictment? And are you pleading guilty because it is true as it is alleged?
Yes, sir.
And paragraph 2, which alleges you were finally convicted of the second-degree felony of robbery on December 17th, 2019, in cause number 19-30936 in this criminal district court of Jefferson County, Texas. Is that allegation true and correct as it is alleged?
Yes, sir.
And are you pleading true and correct to that voluntarily and because it is true?
Yes, sir.
All right. If found guilty, do you understand you are facing a third-degree felony based upon paragraph 1 of the indictment? And if paragraph 2 is proven true beyond a reasonable doubt, then that punishment range can be enhanced to a second-degree felony, as we've talked about here in the accordance with this plea where you are looking at up to 20 years in prison?
Yes, sir.
All right. How do you plead? Again, in this case, are you guilty of paragraph 1 and true to paragraph 2 of this indictment, which constitutes a third-degree felony, enhanced punishment to second degree?
Guilty.
And are you pleading guilty and true voluntarily? And because all of this is true and correct as it is alleged?
Sir.
You understand? That you have given up your rights to a jury trial as to the guilt or innocence phase of this case by entering your guilty plea.
Yes, sir.
You have reserved, though, your appeal, if you wish, as to what punishment may be assessed by the jury.
Yes, sir.
What's marked as State's Exhibit 1. Did you sign that document voluntarily, understand it, discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection, it's admitted. And this states that you were mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial as to the guilt or innocence phase of this case, and the right to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
State's Exhibit 1 tendered into evidence without objection. And again, how do you plead to paragraph 1, charging you with this third-degree felony of evading arrest or detention, guilty or not guilty?
Yes.
And to paragraph 2, are you pleading true to that allegation of commission of second-degree felony robbery on December 17th, 2019 in this court?
Yes, sir.
Or you're entering your pleas voluntarily, knowingly, intelligently, and because all of that is true?
Yes, sir.
Find that you understand and appreciate the consequences of pleading true. Anything else to add?
Judge, just real quick, I just want to make sure the record's clear that Mr. Phillips and I have discussed the options between presenting sentencing to the court and presenting to the jury. And he is one of the key distinctions being that the court can grant probation if the court found it warranted.
I can grant deferred or unadjudicated probation.
Correct.
That they cannot, a jury cannot.
And so, and Mr.
As well as straight probation. The court can.
Yeah. And
Where the
because
jury
he's-
cannot.
Because he has a final conviction, then he is ineligible for probation in front of a jury.
And I was just making sure we discussed that correctly, Mr. Phillips.
Okay.
Yes, sir.
Okay.
You understand all of that, and you, knowing all of that, you insist on pleading guilty to the court and asking the jury to assess the punishment in this case.
Yes, sir.
Okay. Then I find that the defendant is pleading guilty voluntarily. He is mentally competent to do so. He understands and appreciates the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here. to find you guilty beyond a reasonable doubt of this third-degree felony of evading arrest or detention with a motor vehicle. I find you guilty beyond a reasonable doubt of that offense. And we will move forward to the punishment phase of this trial. When can we set that?
There's something better on trial documents.
Yes, that's what we would do. We need to move it to a court docket to get it done.
Does Your Honor want to consider it for tomorrow?
No, I got other things on this one this week.
Yes, sir.
Nothing else. We'll figure it out and get back with y'all. Okay, but it will be done as soon as possible. Yes, sir. Thank you.
So Austin put in the chat that he found it interesting that you could plead guilty but have a jury sentence you. I have information on that for Texas. We'll cover that in hour 4. Hour 4 is going to be busy potentially. We've got that Judge Collada case from this morning. The Stevens one, where the guy got 10 years for his crimes against children. The Middleton one that we just watched for sure. Plus I've got information on aggravated assault in Michigan and how it's charged, and then this Texas info. Plus I've got a few news stories we can go to as well. Again, channel members, you can join me in hour 4. There's a link in the Discord in the channel or the membership announcement section. So if you have comments on any or all of this, please do join. It's your chance to speak out. In the meantime, though, we're not quite there yet. Back across the hallway, it's Jefferson County morning all of a sudden.
You know, I spoke with counsel about it. There's something I need to look into. Evidently, there may be something on the exculpatory that may be dismissal, but I have to check with the
Okay.
witness.
All right, we'll just do a normal reset. I don't, it looks like there was a lot of resets just to get to this point before you got appointed. So I know you haven't been on it very long, but the case is getting old. So I'll do a reset, make sure you get that taken care of and see if y'all can get something taken care of before that next court date if possible. Okay, stay in touch with Mr. Lewis so that after he visits with Mr. Hoffpower, you'll know what the options are in your case and we'll get an announcement at the next court date. All right, you're free to go. Thanks.
Thank you.
Mr. Rojas, you have Krishara Bennett, it's a sentencing. Krishara Bennett, sentencing. Bennett, sentencing. It's all right. Good morning, are you Krishara Bennett? And Ms. Bennett was previously in court, entered a plea of guilty to credit or debit card abuse against an elderly victim. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yeah.
Are there any additions or corrections?
Not from the state judge ordered it, other than we would ask that the court order the restitution and also that she forfeit any kind.
Yes, ma'am. All right, Ms. Bennett, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 5 years. You are ordered to pay restitution in the amount of $2,256.92. You are ordered to forfeit your CNA and home health care license and follow all of the other rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have a felony conviction on your record. And if you successfully complete the probation, then at the end of the probation, the case is actually dismissed. You'll never have a felony conviction. The other side of that, however, is if you violate any condition of probation, you can be brought back into court, you could be found guilty, so you would become a convicted felon, and you could be sentenced anywhere in the range of punishment, which is between 2 years and up to 10 years. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. You need to have a seat here in the courtroom. Probation will call you up to her desk when she's ready to go over your paperwork. Good luck to you, ma'am. See, Janisha Leonard, sentencing. Oh, sorry.
So apparently somebody,
This is,
somebody's coming over.
Janisha Leonard is?
It is.
Oh, okay, shows on here Mr. Nichols, but I'll make that.
I think Luke took the plea.
Okay. Okay, you're Janisha Leonard? And Ms. Leonard entered entered a plea of guilty in cause number 25 DCCR 0297, and then pleas of true in cause numbers 19 33340 and 20 36095. Those were all unagreed, on probation for state jail felonies in each of those cases, and then the new case is a new state jail felony, theft of property. I've received the pre-sentence report and reviewed it. Has everyone had an opportunity to review it?
We have, Your Honor.
Are there any corrections or additions?
Not from the defense. Not from the state judge.
Mr. Coleman, before I get started, and I just noted the date of the new offense compared to the date of indictment, and wondered if you know why that took so long. That offense is dated, the offense date is August of 23, and it was not indicted until sometime in 25.
That's right, Judge. I didn't snap to that before you mentioned it. I don't have an explanation for that.
And so I guess my question, obviously on the face of this, typically I would be leaning one way, and y'all know which way that is. The length of time, though, from the date of that offense to the date of indictment, and that nothing, she on probation and doing, looks like somewhat okay between that time, makes me have some concerns. She now has a new baby. There's some positive things in the pre-sentence report about what she's been doing since then. And so I could hear between August of 23, which is that, the last 2 years or so, other than that new allegation from 2023, how has Ms. Leonard been doing on probation?
Judge, she's been making slow progress, but within the last few months, she's been really stepping up with community service hours and paying towards her fees.
I mean, on paper, there's no reason for me to be considering another probation, except that time frame and the state, Mr. Powell from Sutherland's would obviously like restitution. I don't know that that's gonna happen, but Mr. Coleman, I'm gonna go to you first this time.
Judge, I don't have any strong feelings about it. I think the court makes some good points. I certainly understand why the court would entertain putting her on a probation for this new case and continuing her on the probation she's currently.
And if they're all state, this is a state jail. Are they all already 5 years? Are they, what's the length of the probations? I want to make sure they're all.
The 5-year and case number heading in 340 and one and 095 is 5 years.
Are they both deferreds?
Those are straight probations.
They're both straights? Okay. Part of what I'd considered was if it was deferred, revoking and then doing it straight, but that's not an option. But we'll start with another 5-year if I do that today. So I guess we have 5 more years. And have you talked to her about the restitution amount that
Judge,
was?
that was one of the things I was going to bring up. The amount is, she has a different amount. I would ask if you're going to put her on probation and order restitution, let probation determine what it is. There's a substantial difference.
I have to order it at sentencing. Do you have any records from Sutherland's to back up that amount? I mean, it's a very specific amount.
It's just, I've got kind of a packet here that the complainants put together.
Why don't I do this then? What I'd like to do is reset sentencing just for a week or so, give you some time to go through that. I'll do 2 weeks, give you some time to go through that with Ms. Leonard. If we need to have a restitution hearing, if you'll let Mr. Coleman know that there's not an agreement, or if y'all can't work out something after you look at it for some amount, either what they're requesting, or if you see something that may not be in there, we'll have a hearing, short restitution hearing. So we'll reset 2 weeks for sentencing. All right.
Okay, this is scanned in, it should be in the next one.
This came in, I'll go back. If I have it, it's not.
You're free to go, ma'am. Stay in touch with Mr. Rojas because y'all will need to get together before that next court date.
Okay, I'm getting just 1 or 2 more things ready before we go into overtime. So in the meantime, back across the hall, one last hearing with Judge Stevens.
I'll do a backup on that one.
I've got Adrian Williams before that. The state's ready on that.
Yeah.
He's in jail. It's a possession of firearm.
Who?
Adrian Williams.
Yeah. And then 3, just to be on the safe side. On Wyman Clover,
I'm ready on that one.
you ready?
Yeah, I can do both.
That's the one she's missing the fighting witness on, I believe, Judge.
All right. And then on Mr. Ham, on Kobe Rogers, we're postponing that one, right?
Yes.
Yes, please, Jeff.
What about Jarek Holman? Are y'all ready? Can you go on that one?
Which one, Jeff?
Jarek Holman with Burbank, illegal possession of a firearm.
Good judge. I'm ready on that case. And I'm also ready on Adrian Williams at above that.
Okay, Davis is first, Williams is second, Jarek Holman will be third. And then we need to get those, the Arnold and Rogers and more, they'll reset very quickly. Those are very serious. And then Clover as well. Okay. Oh, this is Jamichael.
Harris.
Malachi Harris.
Hey. Here's Phillips's 2 cases. Malachi Harris. 24 CR 1329 was called, the state of Texas versus Malachi Harris. That is you. Present with your attorney. Mr. Adams and the state's attorney does the defendant waive a formal reading of the indictment and arraignment can we proceed in summary?
Yes, sir.
In summary, 24 CR 1329 alleges that on or about April 28th, 2024 in Jefferson County, Texas, you committed the first degree felony of aggravated robbery. Do you understand what you were charged with here, sir?
Yes, sir.
If convicted of a first degree felony, you face a term of life imprisonment or any term of not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached in your case where you would be pleading guilty, sentenced to 8 years in prison, given credit for all time you have served. Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this, sir? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily on your own free will and because you are guilty?
Yes, sir.
I'll show you what's marked as State's Exhibit 1. Would you sign that document voluntarily, understand it, discuss it with your attorney? Are the contents true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection, it's submitted. Among other things, this states you are mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged and any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
State's Exhibit 1, part of the record for all purposes. Pre-sentence report is way to it.
Yes, sir.
Anything to add by anybody?
Nothing further from the state judge.
Okay. Anything you would wish to add, Mr. Harrison? I'm going to follow this agreement
Yes, sir.
and find, if nothing further, you have pleaded guilty today voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this first-degree felony of aggravated robbery. And I'm following this agreement. You are hereby sentenced to confinement in the Institutional Division of the Texas Department of Criminal Justice to serve a term of 8 years. And the judgment shall reflect affirmatively in a finding by the court that a deadly weapon was used or exhibited, namely a firearm, in the commission of this offense. Do you understand what has happened to that, sir?
Yes, sir.
Anything else to add? That is all. Thank you. Oh. Here we go. Thanks.
Okie dokie, friends. Racking up some things here at the last moment. But let's go to TCF overtime. Hope you all had fun in court today. I know I did. Definitely some defendants that didn't have as much fun, but they earned it, didn't they? So again, if you want to join me here, there is a link in the Discord under the member announcements. So if you're a channel member, you can join me. So again, we can talk about Judge Collada, Judge Stevens, Judge Middleton, and the cases they had. Lots I have to say on it. Plus, I've got a couple of news stories if we have time for those as well. But let's start with Texas, because I believe it was Austin who expressed interest that the guy could plead guilty but then wait for the jury to sentence him, which, to be honest, isn't something that I'd necessarily run across before either. But again, especially if you're new to the channel, I'm not like an attorney or anything. I'm just some guy who likes watching court. So I learned too, and that's the beauty of TCF, is that we all learn things. But I pulled up information on Texas. Specifically in Texas, a defendant can plead guilty to a jury, which then becomes responsible for assessing the punishment. A process often used when seeking a more lenient sentence than the judge might impose. The jury will hear evidence from both sides regarding the offense and character to determine the sentence. The procedure is, while the defendant pleads guilty, a jury is still impaneled to hear the evidence. The jury's role is to determine the sentence rather than the judge. Obviously a strategic move there. And it's often used as an alternative to a plea bargain if the defendant or his lawyer thinks that they can do better in front of a jury. Interestingly, the jury is not bound by anything that's been pre-negotiated. They just simply have to sentence within the guidelines. Different from a bench trial, obviously, in that the judge really has no role other than to accept the plea. So there you go. That's how that works in Texas. I had no idea. Now we learned something. Let's start with Middleton. And just to refresh you, this is the case we saw a little while ago where the woman was at Yoder's, which is this like Amish grocery store thing in Centerville. And again, all my years in Michigan, I'd never actually been to it. But I think I should go the next time I go to Michigan because I had a chance to kind of look at the place and it looks really cool. Can't believe I've never been there. That's okay though. But I have pulled up compliments of our friends at Google Maps. This is the donut case that woman was shoved into. And you can kind of see in standard Amish fashion, you know, this is like super heavy construction, this thing. Actually, let me flip over to this screen share here, if I can. Remove that one. There we go. Anyways, yeah, so I can kind of flip it around a little bit. You can see this is, you know, standard Amish construction, big heavy wood doors. This is no like wimpy thing that you would find in a Kroger or something. It's a serious case that she got shoved into. So I could see where she definitely got injured. And she was talking about like her knees being messed up too. But if you look at this counter down here, that counter's kind of at about knee height for probably a lot of people. So that makes sense too if she was shoved in there that her knees got messed up as well. So, and it's really messed up. But one of the things that we talked about, or we were questioning while we were talking about this case, was the idea that the assault was a misdemeanor. So, yeah, Dan is doing advertising. Maybe. Yeah, I kind of want a donut now myself, to be honest with you. They had, I saw some pictures. They had donuts with like bacon on them and stuff too. So super yummy. Anyways, in Michigan, aggravated assault is generally classified as a high court misdemeanor. So punishable by up to 1 year in jail, $1,000 fine, or both. So, per the definitions, aggravated assault involves serious or aggravated injuries, such as those requiring medical treatment, but which are not considered great bodily harm. Felonious assault, on the other hand, also known as assault with a dangerous weapon, is a felony punishable by up to 4 years in prison and up to a $2,000 fine. And then there's assault with intent to do great bodily harm, which is more severe yet, up to 10 years in prison. And then domestic violence is categorized separately in Michigan. The first offense is a 93-day misdemeanor. You get up to a third offense, though, and you raise it up to a 5-year felony. So that's how things work in Michigan regarding that. I know, Michael, you had a question about why it was just a misdemeanor, but that's the reason. There was no weapon involved. And I guess they didn't classify it as assault with intent to do great bodily harm. But I don't know. It's so interesting how the courts look at these things, isn't it? Because I don't know how you could take somebody, shove them into a case like that one we just looked at, and not expect that you would do great bodily harm, or potentially. I mean, you know, there was a potential, obviously, for cuts all over her, which she did have, but I mean, even more severe. Potential for broken bones. You know, depending on how her head went through the glass, if she'd nicked the right portion of her neck, she could have bled out. So I think you definitely could have made a case to call, in my mind anyways, to call that assault with intent to do great bodily harm. But, you know, in Michigan, and it seems so often, especially compared to other states, that they tend to, in a lot of ways, charge softer there. I don't know why, but they do. At least that's, you know, anecdotal, what we see here on the channel. And it's a little bit messed up, in my opinion. But I think this case for me, and by the way, he got 100 days, credit 38, But specifically, the judge made it possible for Cass County to come get him because apparently he's got something else in Cass County that he's on probation for. I don't recall the specifics, but I seem to recall it was a felony, and if that's the case, then this probably violates that, and I think Middleton is hoping that that will result in a prison sentence for him. I could be wrong, but I don't know. I'm hoping that's what he hopes there because it was light. But the bigger thing that this case spoke to me about is just the senseless nature of the violence that we're seeing across the United States right now. Again, this is just one piece of a larger puzzle of what we're seeing, but it's true. People doing stupid things, and I don't know if it's becoming more and more of a regular thing or if it's simply the fact that we all have internet access with 24/7 news cycles, so we're seeing more of it because of that. I don't know which, but if I think about how the world worked when I was younger, growing up in the 70s and 80s versus how it works now, it feels different to me. I don't recall this level of stupidity. I mean, there was stupidity for sure, but it seems like it's everywhere now, and it's not good for us. It's not sustainable. We can't keep acting fools like this and doing stupid things like shoving a lady into a donut case, apparently just 'cause. Didn't seem to be any reason other than that, although didn't he claim that he claimed he tripped. I wrote the note on that. But then as I recall, the security footage showed a totally different story there. But so, just some guy acting a fool just decided that he's going to assault somebody just for the sake of assaulting them. And that's just not going to fly. We can't be like this. We can't sustain it. It just doesn't work. I don't know. There's so much I could say on it, and I don't want to get like super duper preachy, but the thing I like about this community is I think that we all kind of have our heads right, but so many don't. Lindsay said he also may not have been in his right mind, which isn't an excuse but a fact of the case. Well, that could very much be the case as well, Lindsay. He could not have been in his right mind. But then we still have the failure of mental health that we've talked about 1,000 times over, don't we? And I guess there's also the question of what has he done to not be in his right mind? Is there any substance abuse there? Was he drinking beforehand? Doing some kind of drug? I don't know. But at some point, even if you have issues, I think there has to be something to be said for taking some agency in your issues. And if he's good enough to sit in front of the judge and talk fairly eloquently for the few words he did say, to understand what he's going through, because obviously they didn't have a competency concern there, then there ought to be enough in there for you to equally realize that you have a problem that needs to be dealt with, at least on some level. So it's probably a mix of things. There's the fact that we don't do enough for mental health, but then there's also the fact that he's not taking enough agency in his own life to address whatever he might have. Or he was just drunk or high, or just acting a fool. There's so many possibilities there. But however you slice, dice, and julienne fry it, it's not sustainable, and we can't keep doing this as a society. So those are my thoughts on that one. Head southeast over to Lake County, Ohio, and Judge Collada. So if you recall that case, that was the drug addict guy. Now, if I recall, he said he was 20 plus years into his addiction issues. He has kids because he was worried about not being there for them. And he was stealing from the place where he worked to the tune of $6,006.18 or something like that he has to pay in restitution. And this guy, he committed the cardinal sin that we constantly talk about here in so many ways, and that's just show up. All he had to do was show up, and he didn't show up for his pre-sentence report, the pre-sentence investigation. So the option of even giving that guy any kind of probation was taken off the plate for the judge. By law, according to what the judge said, he was not allowed to actually consider him for probation because the pre-sentence report was not done. So again, people acting fools. And the one thing, he had one job, show up, and better things probably would have happened. But he didn't. But here's the thing, 9 months. He steals over $6,000 from people who are trying to look after him and trying to take care of him because they'd mentioned that they were constantly giving him advances on his salary and stuff too to try to keep him going. And he's still stealing from them. But there we only see 9 months. I don't know if that's, we've talked about that before though. I say I don't know if it's enough, but in the same respect, we've talked before about how if these people who have the financial crimes, if they're put in jail or prison for too long, then it makes it harder for the victim to receive any kind of restitution. Plus, they don't receive restitution with any kind of interest, which, just means that, and Judge Stevens has references in his court where they're losing the ability to use that money, and the value of the money keeps going down, especially in the current economy where inflation is kind of out of control still. I don't care what anybody says, it's still a problem. So they're losing the value of all of that money the longer it takes for them to get their money back, which sucks. But so I'm really torn on that one. If you've got other thoughts, tell me. But there's a part of me that feels like he should have gotten a lot more, if for no other reason than if he's in prison for a couple of years, maybe fingers, toes crossed, he could get enough services to break that addiction situation. But in the same respect, I realize that the longer you leave him in, the harder it is for restitution to happen. But this is another one to me that speaks to the concept of drugs not being a victimless crime. I know that a lot of you out there disagree with me on this point, but I am staunchly anti-drug, and I'm not going to claim that I'm not. I line up much more behind the Judge Elmores of the world, who has flat said to people, I'll take on anybody in a debate about whether or not drugs are a victimless crime. Because here you've got a drug addict who's going to jail for 9 months, which means his family is without him, his kids are without him, his employers are without their $6,000 because he's out there doing drugs and being a fool. So there are definitely victims. We can claim all day long that we don't care what somebody does with their body and what they put into it. And that would be great if that person was in a vacuum. But they're not. They never are. Because you can't go through society. You can't live on this planet without interacting with others. So your actions at some point end up affecting others no matter what we do. So I don't know. Again, another person acting a fool, and this is just not sustainable. And then there's the Middleton case. Or not the Middleton case, the Stevens case, rather. And this was the guy who did crimes against kids. He had 3 charges against him: sexual assault of a child, indecency with a child 2nd degree, and indecency with a child 3rd degree. They dropped the indecency 2nd on that plea, which left him with the sex assault 2nd and the indecency 3rd that he was charged on. And he got 10 years. Which is probably closer to appropriate than what we normally see out of Stevens Court or any of the courts, because so often, and we continue to not understand exactly why this is the case, but it is the case. We know it because we see it all the time. We have these crimes that happen where a child is involved, and then so often these guys get a slap on the wrist. It's not punished, generally speaking, as harshly as it should be. We've joked, but it's almost not a joke. Where if you take a fish out of season in Florida, rather, it's like 32 consecutive life sentences. But then you go to Texas and you do something to a child, and my joke is that the judge will take you to the Sizzler for dinner that night. So a little more credit, but 10 years still feels incredibly light to me. These ought to be, I don't know, tell me if you think differently, but I feel like these ought to be at least 25-year deals, especially when he's admitting to it. This isn't a I'm professing my innocence the entire time. He did a plea here, so he's taking responsibility for it. And there you go. Wahoo says there should have been a lifetime registry. He was forced to register, but I thought it was lifetime. I could be wrong. But he did point out to him that he has to be on the registry. But what good is the registry other than perhaps, keeping you from being employed and perhaps affecting where you live to a certain extent? But go scan your neighborhood. Just about everybody's got somebody on the registry in their neighborhood. So I don't know at this point what good it does. But that could also speak to just how prevalent this crime is, because we've talked about that too. And I swear to all of you, I don't pull these hearings up on purpose. I really don't. But we stumble into multiple things usually, every single day. Every single day there's something out there. It doesn't matter, it seems, where I go, what court, what state, what county. Somebody's doing something bad to a kid, and we encounter it. And there's very little exception. Oops. Okay, we're back. I lost signal over here for a second, but I guess it's still working. But it's just nuts. I mean, I don't know. Like I said, you can't not see this stuff constantly, and I worry, I suppose, about what that continues to say about our society, because it's really messed up. And we don't seem to punish it hard enough. But partial credit where credit is due. I suppose this is better than we normally see out of Middleton, or out of Stevens, rather. Normally it's a slap on the wrist. I still think this is light, though, but that could perhaps be me. Anywho, if you want to talk about any of those things, feel free to hop on in and we can do so. In the meantime, outside of what we saw today, so I ran across this morning, and this wasn't even something that was on my radar. It might have been on your radar. But this is definitely fascinating to me. So this guy named Ryan Wedding, he was an ex-Olympic snowboarder for Canada, as I recall. And he was arrested in Mexico by the FBI for being a drug kingpin, which is nuts. So let's see what this says. This is from Yahoo Sports, but there's a bunch of different outlets that have reported on this now. Former Olympic snowboarder Ryan Wedding, arrested in Mexico, an FBI announced on Friday. Wedding, 44, was on the FBI's 10 most wanted list for charges that included murder and money laundering. He's also accused of being the leader of the largest cocaine distribution operation in his native Canada. The FBI had announced in November it was increasing the reward for information leading to Wedding's arrest and or conviction from $10 million to $15 million. It's a crazy award for this guy. Plus, you know, if he was an Olympic snowboarder, then he's got a little bit of fame, I would think. Shouldn't have been that hard to find him, but FBI Director Kash Patel posted on social media that Wedding was arrested in Mexico and will be transported back to the U.S. Quote, "This is a huge day for a safer North America and the world, and a message that those who break our laws and harm our citizens will be brought to justice." Wedding placed 24th in the parallel giant slalom as part of Team Canada during the 2002 Olympics in Salt Lake. The Department of Justice claims that since then, he built a criminal enterprise that worked with prominent Mexican cartels to move hundreds of kilograms of cocaine from Colombia into Mexico by boat or plane, and then into the U.S. and Canada via semi-trucks. Additionally, authorities allege that Wedding's group orchestrated the murder of 3 people, one of them a federal witness who was set to testify against Wedding before he was gunned down at the restaurant in Middleton, Colombia. Wedding allegedly found the witness by posting his picture to a website that has since been taken down. During a November news conference, Pam Bondi called Wedding one of the most prolific and violent drug trafficking organizers in the world, while Kash Patel described him as a modern-day iteration of Pablo Escobar. Bondi claimed over 2,000 kilos of cocaine had been seized over the course of the investigation, as well as numerous weapons, $3.2 million in crypto, and $13 million in other assets. Wedding also faces separate charges from a 2015 drug trafficking case in Canada. He'd been previously convicted in the U.S. of conspiracy to distribute cocaine and was sentenced to prison in 2010. If convicted on the murder, he faces a mandatory life without parole. So, again, this one, it kind of escaped me. I wasn't even aware this was a thing until I ran across this story this morning. And maybe I just don't have a big enough criminal mind, which is probably a good thing. But how do you go from snowboarder to drug kingpin? That's the biggest question that I have from this one. I mean, I suppose you could claim you're moving from powder to powder, haha, but I don't understand where the synergy is there, where the crossover is. It doesn't add up to me, because if you, maybe I'm naive and maybe I'm wrong, but it feels to me like if you're going to rise to that level in that kind of crime, it feels to me like it's something that you would have more grown up around. You know what I mean? And been like trained in it. And maybe he was, and the snowboarding thing was just kind of a pastime that he got really good at. I don't know. Because, you know, 2 things can be true at once. You can be a criminal and a good athlete. Like, we've never seen that before. You know, Michael Vick, great quarterback, also loved to do bad things with dogs. So I suppose that's true. But I wouldn't suspect that growing up in Canada, playing on the hills in the mountains with your snowboard suddenly leads to, when that career is over, you becoming a drug kingpin. Again, maybe I'm naive, but I don't remember growing up in Michigan and going out skiing and seeing a whole lot of drug trade up at like Boyne. I don't know. Lindsay, do you remember that? You grew up in that area. I don't recall it, but it's weird. Strikes me as weird. But I'm glad they got him, and hopefully he's brought to justice, because it sounds like they've got a pretty solid case there. All right, one more story for you guys. There we go. Another thing. This is from Courthouse News. This speaks to a bunch of the fraud that we're seeing around the United States. Hadn't seen this one yet before, though. LA homeless housing provider charged with stealing $10 million in funding. A Los Angeles provider of housing and services for homeless people was arrested Friday. Friday was a big arrest day around the... Maybe not Blaine, probably Crystal, though. All right. Fair enough. I never frequented Crystal, so I'll leave that one up to you, Lindsay. Los Angeles provider of housing and services for homeless people was arrested Friday on charges he stole at least $10 million from funding intended for the unhoused and used it to fill his own piggy bank. Alexander Sufer, 42, charged with wire fraud, according to an announcement from the U.S. Attorney's Office in L.A., faces up to 20 years in prison. He won't get that much. He'll get 10 out in 7.5. That's my bet. Sufer is the executive director of Abundant Blessings, a charity based in Hyde Park neighborhood of South LA. He received $5 million in contracts from the Los Angeles Homeless Services Authority to provide housing for people who were homeless or were at risk of becoming homeless. He also received more than $17 million in contracts through a downtown LA-based nonprofit called Special Services for Groups Incorporated. Federal prosecutors accuse him of misappropriating the money to bankroll a lavish lifestyle that included luxury improvements on a $7 million house in the LA upscale Westwood neighborhood, $475,000 for what appears to be a vacation property in Greece. Okay. Private schooling for his children, lavish spending in Las Vegas, private jet travel, and stays at luxury resorts across the U.S. from Miami to Palm Beach. Sufer is also accused of failing to appropriately shelter and feed the homeless at his sites. Christ. Forgive me for that, Lord. So not only is he stealing, he's not even using the money that he doesn't steal to properly take care of the people who he is supposed to be taking care of. After receiving hotline complaints and seeing anomalies in his billing and services, LAHSA and city investigators conducted site visits, and prosecutors say found that the only food services were things like ramen noodles, canned beans, and breakfast bars rather than 3 meals a day he was getting paid for. Charges against Sufer follow those the U.S. Attorney's Office brought last year and against 2 others for defrauding local and state agencies that fund homeless aid programs. And I don't even need to read the rest of that. We spend, as a country, ridiculous amounts of money, crazy ridiculous amounts, every year on trying to help people around the United States, whether it's the homeless population or those who aren't making enough money to feed their families or whatever the case may be. And it is always just so rampant with fraud. This has kind of become a little bit of a broken record too, hasn't it? I mean, we see it all across the United States. I mean, famously, there's some questions about daycare going on in Minnesota right now. There's this. We see it everywhere. And I don't know. Like I said, if you hang around me long enough, you know that I'm very big on preaching about doing the right thing, about being responsible. If you do make a bad choice, you take responsibility for that and accept it. I don't know. I can't fathom in my mind doing a crime as big as taking, what was it, 10 million or whatever dollars out of the hands of those who need it just to survive. Because, I mean, even they're not going to see the full benefit of that because of the overhead that has to go into helping these people. But still, to pocket it yourself and get a vacation home in Greece and a bunch of trips and private jets and everything else while everybody else is surviving on ramen and breakfast bars, it's a problem. Yeah, Kelp says infuriating. How aren't these orgs getting vetted better? Well, that's a question, isn't it? I mean, it could very well be that you have a situation where the people who are supposed to vet are overworked, so they just push through the paperwork and don't pay a whole lot of attention. It could be payoffs, because it could be that they're corrupt, or it could be corrupt in another way, that the people who would vet it are in on it as well. I don't know. There's so many different reasons why that could happen. All we know, I suppose, is that it does, but we count on the goodness of others, and there's so many out there that do good, and I don't want to throw everybody under the bus, but too often we see examples of those who don't do good, those who don't have our best interests at heart, and then we see things like this. This one just bothered me, though. We see theft all the time, but this is an especially egregious one to me, just because, again, this is supposed to be trying to help people. Well, some try, at least. I agree, Ashley. Some do try. Charles writes, going back to the wedding thing, wedding started out growing marijuana in British Columbia and I guess expanded into cocaine. He was pretty good at evading prosecution at first. Okay, so snowboarding and marijuana, I can see those going hand in hand. There's a lot of culture crossing there, because you see it in like the snowboarding and the skateboarding community. That makes sense to me. So, it's often talked about how marijuana is a gateway drug, but I didn't think they meant that in this fashion, where it's a gateway from growing and selling marijuana into growing and selling cocaine. But there you go. I don't know. It's a weird, weird world, my friends. But the good news is that we're all here to experience it together, and you guys are great. So that's the good part. Well, friends, I don't have much else to share with you today. Michael says growing and selling marijuana isn't nearly as profitable as cocaine. Well, that's very true, especially now that weed is legal. Yeah. Now they kind of shut down that market. Unintended consequences, once again, though, I suppose. You shut down the illegal cocaine or illegal marijuana market, and people are going to move over to cocaine, I suppose. So there you go. All right, my friends, I'm going to call it a day, just a few minutes early, but I've covered really everything I want to cover. We'll be back tomorrow, 9 a.m. Eastern, 6 a.m. Pacific, half an hour early for channel members. Plus, we have Sidebar tomorrow night at 8 p.m. Eastern, 5 p.m. Pacific. Not sure what we're talking about yet. We got to figure that out today, gang, but we'll be back tomorrow. So thank you so much for spending 3 hours, 45 minutes with me. I appreciate it. It's been a good day. Thank you all so much, and I will see you tomorrow. Take care. God bless.